At this time, the court calls State of Wisconsin versus Stephen Avery, case number 05CF381. We're here this morning for a continuation of a trial in this matter. We're outside the presence of a jury at this time. Will the parties state their appearances for the record, please?
Good morning, Judge. The state appears by Special Prosecutors Ken Kratz, Tom Fallon, and Norm Gahn.
And good morning, Stephen Avery in person, Jerome Buting and Dean Strang on his behalf.
All right, counsel. I understand that the parties have something to take up outside the presence of a jury.
The defence has a brief motion, Your Honour, in light of the court's rulings at the end of the day yesterday. The defence all along has been consistent in contending that there were no reliable tests that can be done that would be useful to the jury on the dried blood stains in the Toyota or the blood vial in the clerk's office. The court ruled as it did yesterday, leaving reliability to the jury and ruling the state's test performed during this trial otherwise admissible under Wallstat. That will not allow. It's no surprise, as we said all along, that will not allow any rebuttal testing or independent testing that might be offered to rebut the state's testing now that the state has chosen to pursue that and the court has allowed that testing regardless of its reliability. So I have a two-pronged motion to preserve Mr. Avery's rights and options. First, I would like the court to order that all samples remaining of swabs or the dried blood stains themselves in the Toyota RAV4 be preserved indefinitely and not destroyed or damaged, absent further court order on application by the state with notice to Mr. Avery and whoever his counsel may be. And, as well, that the blood vial from the clerk's office be preserved, not damaged or destroyed in any way, absent further express court order on application by the state with notice to Mr. Avery and counsel, so that we preserve the ability to test if and when science advances to the point of allowing some reliable testing or just rebuttal testing by the defence. Second, I would like the court to enter an order now that the defence will have access to the swabs from the Toyota. And when I say swabs from the Toyota, I'm referring both to swabs of the dried blood stains and the control swabs that were taken for purposes of the FBI testing to which Dr. LEBEAU has testified, as well as the dried blood stains themselves. All the dried blood stains in the Toyota attributed to Mr. Avery and the blood vial from the clerk's office. I would like the court to order now that, without further application, the defence may conduct independent testing of any or all of those materials at any time from today through trial. If there's a conviction, post-conviction, in the appellate process or after the appellate process, I would like the ability to do that testing when it reasonably becomes available to Mr. Avery to do it as a matter of science and finances, regardless of when that may happen. It won't happen during the trial, so I'm just looking ahead. Of course, if he's acquitted, everyone will lose interest in testing. But if he's convicted of any of the charges, this evidence that the state contends is so material to guilt or innocence will retain its materiality to guilt or innocence. And I would like the court to order that Mr. Avery or his counsel have access to that without further order of the court for testing at any time.
Who will be speaking for the state?
I will, Your Honor.
Mr. Gahn.
I have no objection to anything that Mr. Strang has stated.
All right, just a practical matter. And I'm testing my memory here a bit. I thought that the samples from the RAV4 were already split, such that in order to enable both parties to conduct testing if they wished. I'm wondering if the court is going to issue an order that samples be preserved. I guess rather than leave it that broad, I would like to know where they are now, and perhaps the order should reflect how they should be preserved or where they should be preserved.
My understanding is that the samples from the RAV4 were submitted for EDTA testing, which would have been A8, the swab from dashboard, A10, the swab from the CD case in Teresa Halbach's car, and A12, which was the bloodstain swab from the metal on the rear passenger door entry, that Mr. Buting requested that the FBI preserve one half of each of those samples for independent testing. That has been done. one half of those swabs are preserved. Also, Mr. Buting requested that controls were taken. Also, the FBI only consumed half of those, and that is the case. So one half of the controls are available. As far as the other swabs, which were taken by Charee Culhane, those are in the control of Calumet County Sheriff's Department, and those are also available to the defense. And one half of the A10, A12, and A8 have been returned by the FBI, and they're in the control of the Calumet County Sheriff's Department.
Alright, so the understanding is that these items are going to be retained at the Calumet County Sheriff's Department. That's where they are going to be if they are needed?
Yes.
That's very helpful. What it leaves uncovered, or that we haven't covered here, are the dried bloodstains themselves. As there were stain areas for which swabs were not sent to the FBI, if I understood Mr. LEBEAU's testimony correctly, and then the blood vial. And so we just need to know what arm of the state, what agency of the state is preserving all of those.
Alright, so Mr. Gahn, when you say swabs, you mean samples taken from these areas?
Correct.
Was the part of the vehicle with the stain on the dash removed from the vehicle, or is the dash still intact with the vehicle wherever it is?
The dash is still intact with the vehicle, and the vehicle is here on the Calumet County grounds.
Is that going to be saved, or?
Under...
Let me ask first, what has the defence requested? Are the swabs enough?
No, I think the stains have to be preserved, and I suppose the issue then is other control areas for testing. So it would be, I guess, useful to know what the plans are with the Toyota.
Well, let's do this. There's no dispute between the parties that the swabs should be saved. As far as the details of the court's order, that should be addressed. If there's a conviction in this case, and perhaps between the time and that time, should the need arise, the parties could discuss whether or not they might come to a joint agreement on how to preserve samples. I mean, the CD case is small enough that it can be preserved. The dash and the door frame, I don't know if the vehicle will be preserved forever, but perhaps the parts could be removed if it could be determined to be necessary. I'm not sure.
I think that the court is suggesting is prudent. Let's wait until these proceedings are over, because Wisconsin does have a mandatory preservation statute that would be applicable in this case, and it would make more sense to address this under that statute after the proceedings are completed.
I think any order should probably include not only the fact that the samples would be preserved, but a bit more specifically as to how they would be preserved, and both parties may want to be heard on that, or you may come to an agreement with a joint recommendation to the court.
I am only in partial agreement with Mr. Gahn. I do want an order now, at least all the control swabs and the swabs of bloodstains be preserved, and the blood vial, and I have not heard yet whether the blood vial is, or the remaining part of the blood vial is.
The blood vial will be in the control of the Calumet County Sheriff's Department.
Is that where it is now?
Well, that will also become an exhibit very shortly.
Oh.
And let me also say that some of the stains that Ms. Culhane from the crime lab tested, those stains and swabs are in the court record here as exhibits.
What if we handle it this way? The defence can prepare an order to order that all these items be preserved now. I understand that to be not in dispute with the state, and the order can provide that the manner of preservation will be determined following the conclusion of a trial. Does that work for both parties?
Sure, I think so. And we'll have no objection to things like the blood vial and the swabs being withdrawn from evidence for purposes of preservation by the state.
Alright. Is that sufficient detail for you to prepare a proposed order, Mr. Strang?
Yes.
Okay, in terms of, I try to keep an inventory of matters that arise during the trial that have not been resolved. One of those items is the fair testing motion which the defence renewed back in February 27th. If there's time, after the last witness today, I would suggest that the court hear argument on that today. Mr. Buting gave some argument at the time of the motion. Mr. Gahn requested time to respond. I could hear argument from the state, any rebuttal from Mr. Buting, and hopefully resolve that matter today. I also took under advisement Mr. Buting's request to introduce evidence concerning the voicemails and whether or not they were accessed on November 2nd, or that the details of them being accessed. I believe at the time I reserved ruling The parties were going to conduct some discussions with each other to see if the matter could be resolved or if additional evidence was necessary. What is the status of that motion at this time?
Additional evidence, Your Honor, is going to be necessary. Mr. Strang and Mr. Puting have agreed to telephone testimony from a singular technician. We anticipate that to be sometime tomorrow, probably tomorrow morning. That will be supplemented with the state recalling Mike Havak. But that combination of witnesses should resolve that matter. And again, the defense has been kind enough to allow telephone rather than live testimony in that matter.
That's right. And I have also at least suggested in an email last night to Mr. Fallon, and I can't remember if I copied Mr. Kratz and Mr. Gahn or not, but suggested that a stipulation as to one or both of the singular witnesses and Mike Holback, stipulation as to one or both of those witnesses is conceivable. And at least we could try, at least take a stab at that. I don't know whether either side in the end would stipulate, but it's worth a discussion. If we go forward with testimony and not a stipulation from the singular person, we're, of course, working on the assumption that the singular person at the other end of the telephone would have the same documents in front of him or her that we have here, so that the person can be questioned about the documents, and I'm quite certain that the state shares that.
We actually copied 3 court exhibits this morning and faxed them to that person as well.
Great.
So we're working all from the same pages, Judge.
Very well.
And the remaining, while the court is taking inventory, the remaining issue of which I'm aware was my renewed motion to suppress the results of searches of the Avery trailer and the garage and the area behind the garage. I think we settled on after the November 5th search that began about 7:30 p.m. and ended about 10:05 p.m. I had renewed that, several days ago. I think the state, again, reserved response for wanting to be heard on that. And that's my recollection of the issue that remains ripe for decision, or at least further argument and decision.
I was under the impression that we did argue it and the court decided you would rule later after hearing the argument that Mr. Strang and I made last week.
Well, actually, that is right, because now that I hear Mr. Fallon, I recall his eloquence in responding. And the court, at the time, I think, if memory serves, said it would not hear reply from me now or at that point, but we would address the issue in some fashion later.
All right, I will. Do the parties remember what day that was? I'm going to review the transcripts.
It may have been February 22nd, but I can't promise.
I would have to look at the calendar.
I do recall that as well.
I've tried to remember who the witness was right before a particular witness. Right now, for the life of me, I can't think of that.
All right, well, we'll attempt to recreate that a bit later. Are the parties ready for the jury to come in?
Yes.
Yes.
All right, bring in the jurors at this time. You may be seated. Welcome back, members of the jury. At this time, we are ready to read with the testimony. Who will be questioning? Mr. Fallon, you may call your first.
Thank you. The state would call LYNN ZIGMUNT to the stand.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
LYNN ZIGMUNT, ZIGMUNT.
How are you employed?
I'm the clerk of court for Manitowoc County.
And how long have you been the clerk of courts for Manitowoc County?
Since January of 2005.
Tell us, if you would, what are the duties of the clerk of the circuit court for Manitowoc County?
I administer the clerk of court office, oversee the staff to ensure that there's appropriate coverage for all court proceedings, record keeping, oversee all the record keeping in the office, create policies for the record keeping, and oversee the budget for our office.
What kinds of records does the clerk of courts maintain?
All the records for the 3 circuit courts. So any of the case files that are started, any of the filings that are made within the files, correspondence, pleadings, and exhibits that would be filled filed with the court as a result of trial or hearing.
And does that include maintaining files and exhibits from files from cases in the past?
Yes,
In your capacity as clerk of the Circuit Court for Manitowoc County, are you familiar with a case entitled State of Wisconsin versus Stephen A. Avery, case number 85 FE 118?
yes.
And how are you familiar with that particular case file?
I guess from the large interest of the media in that case after Mr. Avery was exonerated in 2003. We maintain the file in our office, so when there are public requests to view the file, we provide it for inspection, and that file was in our office for said purposes.
All right. Now, in your capacity as the clerk of Circuit Court, you supervise other clerks which are employed in that office.
Yes,
And as the clerk of Circuit Court, are you generally familiar with their duties and responsibilities?
yes,
And in terms of your familiarity with the 1985 case, can you tell us, based upon your understanding, of where that file had been kept while in the custody of clerk of the Circuit Court?
From the time I took office, the file was maintained in a large, rectangular shaped cardboard box, and it was in our inner office in the central location, meaning on top of a filing cabinet. And the reason that it was there, I think it was brought up after Mr. Avery was exonerated in 2003, after there was a high interest by the media to look through the file. It was a very big and cumbersome box to have to bring up from the basement where it was normally stored before in a lower level filing area.
I'm going to have some exhibits shown to you, if I may, beginning with a series of exhibits marked 452. Let opposing counsel examine them for a moment or two. While counsel is examining the exhibits, were you asked to bring certified copies of certain documents from case file 85 FE 118?
Yes, I was.
And were you able to obtain copies of the requested documents?
Yes,
And you have received the documents,
I've received them. Oh, right now?
the exhibits.
Yes.
Okay, if you would, directing your attention to exhibit 452, I believe it is, can you tell us what that is?
It's a stipulation filed in the case of State versus Stephen Avery, case number 85 FE 18. I believe it was a stipulation signed by District Attorney E. James Fitzgerald and Mr. Avery's then attorney, Robert Hennick. I believe they entered into a stipulation regarding providing a DNA sample.
All right. And with respect to the last page of that document, is there any marking or seal from the clerk of court, circuit court, which is affixed thereto?
Yes,
Tell us what that is.
it's a seal stating that this is a full certified copy of the original, which is on file in the Office of Clerk of Circuit Court in Manitowoc County and signed by me and dated 3/5/2007.
All right. And what is exhibit 453?
An order in the case State versus Stephen Avery, 85 FE 118, and it's in conjunction with the stipulation wherein the court ordered that Mr. Avery submit to a DNA sample. It's dated November 29th, 1995.
Similarly, is there a certification affixed to that document?
Yes, there is.
And whose certification is it?
My certification dated March 5th, 2007.
All right. And what is exhibit 454?
A letter dated December 6, 1995, from attorney Robert R. Hennick, addressed to the clerk of Circuit Court for Manitowoc County, addressed to Miss Wilda, our criminal clerk, just confirming a telephone conversation where a request was made for a conformed copy of Judge Hazelwood's order to be sent to Elaine Wheeler, Health Services Unit Manager with Fox Lake Correctional Facility.
All right. And exhibit 455?
A letter dated December 12, 1995, from Shirley Wilda, Deputy Clerk with the Clerk of Court Office for Manitowoc County, addressed to Elaine Wheeler, Health Service Unit Manager with Fox Lake Correctional Facility, enclosing a certified copy of the stipulation and order regarding the DNA sample ordered by Judge Hazelwood.
Do the documents to this point indicate the nature of the sample to be submitted for DNA analysis?
What do you mean by the nature of the sample?
Does it specify the form of which the DNA sample would be obtained?
Enclosed, please find a certified copy of the stipulation and order in the above reference referred to case, which orders that a health services unit at Fox Lake Correctional Institution obtain a DNA sample from the defendant as requested by a Laboratory Corporation of America and forward that sample as directed to Laboratory Corporation of America.
All right. What is Exhibit 456?
A letter dated December 12, 1995 from Shirley Wilda of the Manitowoc County Clerk of Court Office to Attorney Robert R. Hennick, enclosing a copy of the stipulation and order, which was filed in the above manner, and just confirming that on this date a certified copy of the stipulation and order was mailed to Elaine Wheeler, Health Service Unit Manager at Fox Lake Correctional Facility, per his request.
And what's the next? Is there one more or two?
One more.
The last one?
Exhibit 457, it's not dated. It's got a file date where it was received in our office, filed June 6, 1996. It is from LabCorp Molecular Biology and Pathology, addressed to whom it may concern. Enclosed, you will find evidence that your agency submitted to the Forensic Identity Unit at Roche Biomedical Laboratories for analysis. And then in parentheses, RBL case number F95-624. Please reference your agency file, Wisconsin versus Avery. So it looks like it's a return of the evidence which was submitted through a DNA sample. I would think returning it to our office.
All right. Now, the 454, 455, 456, and 457, those exhibits, they all have certifications affixed to them.
Yes, they do.
All right. And are you the one who certified?
I certified
those documents?
Them, and they are all dated March 5th, 2007.
Okay. And so they are official copies of the records which are maintained in the Manitowoc County Circuit Court File 85 FE 118.
Yes, they are.
All right. I would like to show you some photographs now, if we may. If you would examine, your attention is directed to Exhibit 464.
Okay.
All right. And do you recognize that?
Yes.
And what is Exhibit 464, please?
It's a photograph of the two plastic tote storage cases where the case of State versus Stephen Avery, case number 85 FE 118, was stored in my office.
All right. If I may publish that now, thank you. Is this a copy of Exhibit 464?
Yes.
It's being displayed on the big screen?
Yes.
All right. Tell us specifically, what is Exhibit 464? What are we looking at here?
This is the entire case file of the 85 FE 118 case for Stephen Avery. The case contains the case file, the paper part of the case file, as well as all the exhibits that were presented in that file.
What is the location of that particular exhibit? In other words,
of the storage cases?
Yes. Where are those? Where was that picture taken?
In my office.
All right. And I believe earlier you talked about the file originally having been contained in some cardboard boxes?
Right. It was in one large rectangular shaped cardboard box, which was very cumbersome to move and carry. It was quite heavy with all the exhibits in one box.
When did the file find its way into the plastic containers which are depicted in Exhibit 464?
I had originally thought like the end of 2005, possibly the beginning of 2006, and I had made a call to my assistant to confirm the exact because I bought those storage totes out of, I was reimbursed out of our petty cash so she could track down the exact date. And she did call and confirm that it was July of 2006 when the purchase was made.
Okay.
So that's when it actually got transferred from that box to those storage totes.
And where was the cardboard box before that?
When it was in our office,
Yes.
it was when you walk into the secured area, like the secured door to our office, it would be like straight ahead, against the west wall of our office, and kind of like a general walkway. Our office is kind of partitioned off into sections, and that's kind of like just an open like walkway. There's one desk on one side where sometimes when people like attorneys want to come in and review a file or something, we would let them do it on the desk that's in that area. And where this file was just a little further past that desk, right in front of like the windows on the side of the building there.
All right. What's the next exhibit you have in front of you?
447.
447?
And that is a picture of the entrance door to our inner office.
All right. 447 is now displayed on the screen. Could you describe for us what we were looking at here with respect to that?
Well, there's a key code pad that's above the latch, and there's an access code that our staff, and I think it's just personnel pretty much that has that access code. And you need that code to gain entrance into the inside of our office.
So if there's a counter I see to the immediate right of the door, under what appears to be a doorbell, what is that counter for?
The counter that's part of, like in our lobby area, there's a counter that surrounds the area where we wait on people over the counter. It's kind of an L-shaped area. That's the short part of the L shape.
Would it be fair to say that there's the general public comes to do business in the clerk of court's office?
Yes.
What are the hours of the clerk of court's office in Manitowoc County?
On Mondays, 8:30 to 5, and Tuesday through Friday, 8:30 to 4:30.
What is the next exhibit that you're holding, please?
Exhibit 448.
And tell us what is Exhibit 448.
It's a package, Airborne Express package, and it was an exhibit, and I believe it's the exhibit that contained the box, the blood vial container.
All right, if we could pull this up, Exhibit 448 is now being displayed on the screen. Is that the package that the clerk's office received from the testing entity, LabCorp of America?
Yes, that's what it appears to be.
All right. What is the next exhibit?
Exhibit 449. It looks like it's the label that is on that shipping package telling what is enclosed as the exhibit. It says enclosed evidence returned from Forensic Identity Unit at Roche Biomedical Laboratory that has been submitted for analysis. Do you want me to read the whole thing?
No, I think we have it here. What is being depicted on the screen here as an exhibit? Is that 449 that you're holding in your hand?
Yes.
That is the labeling of the package in 448?
Right.
All right. And the next exhibit, please.
Exhibit 450, and this appears to be probably the back side of the square container that held the blood vial.
All right.
The styrofoam container, it has markings on, looks like the date it was opened, and it was initialed by the people that were present and witnessed the opening.
Very well. And this box was contained within Exhibit 448?
Correct.
Exhibit 451?
451 is just the other side of the styrofoam container that held the blood vial. It shows the taped end where the evidence tape had been and where it was opened.
All right. So exhibits, I think we began with 464, and then we went 447 through 451. Are those exhibits based upon your knowledge and your responsibilities as a clerk of the circuit court, officially part of the record in the case of State of Wisconsin versus Stephen Avery, 85 FE 118.
Yes.
Your best recollection, Ms. ZIGMUNT, when did the file take up residence, as it were, in your private office?
Probably my best guess would be this July of 2006 when those plastic storage tote containers were purchased.
All right. And what was the general procedure for allowing access to this particular file by members of the general public?
We have a sign-in logbook that anybody who wants to view a public and open record, they sign in it. That would include the date, the case number, their signature. And if their signature would be illegible, we have them print their signature, print their name.
And when did that logbook get created?
I started that in April of 2005. Before that, there was nothing in effect at all to document when files were being reviewed.
And who would, first of all, before we get to that point, let me ask, why did you decide to create such a log?
I just thought it was important. And going to the clerk's meetings, being a new clerk of court, I gained a lot of information at all the different conferences that we have that I have gone to. And that was one of the things that we had discussed. And one of the other reasons I thought would be a good idea to have a record like this was because with identity theft being such a big issue, I thought if we had some kind of tracking device, if there was ever a case of identity theft, we would have something to kind of go back and at least see who was accessing certain files.
All right. And who would be required to sign such a log?
In the beginning, I think I had originally wanted the policy to include everyone, the public and attorneys and anybody who accessed any file. But some of the staff thought, maybe some of the attorneys that come, if they knew who they were, they thought maybe we didn't have to get their signature. Or like for title insurance companies too, because when they come in to look at files too, there would be such a long list. We let it kind of go a little lax on it in the beginning, but I'm not sure exactly what the trigger date was, but probably a few months into it, maybe by October of that year for sure, that we got more strict and wanted it to be inclusive of everybody, every single person who viewed any file. Because I just thought we need a consistent practice. I don't think we can require one person and not another. If we're doing it for a purpose, it's got to be straightforward and it's not serving the purpose, or it's not serving the purpose.
So your best recollection is that by October of 2005, anyone who was looking at a particular file would be required to sign it. Sign in.
Right.
All right. And that included attorneys and everyone, I take it.
Right. It was supposed to include everyone.
Okay. I believe you have now presented Exhibit 454 or 467, is it?
Yes.
All right. And can you tell us what Exhibit 467 is?
It looks like it's a book entitled Evidence Room Case Entry Log.
All right.
And it says Evidence Room, and then at the top of it, it says Journal, so must be some.
And is that the case entry log that people would be required to sign into?
No.
What is that?
I have never.
What is that particular?
I have never seen this before. This must be.
All right. Do we have a picture of, is there a picture of your particular log?
Here? No.
Okay. All right. I just wanted to make sure that we're clear on what that is. Thank you. All right. I would like to direct your attention to the time frame 2005, particularly that year, and begin with this question. Do you know an individual by the name of Andrew Colburn?
Yes, I do.
And who is he?
He's, I believe, a sergeant with the Manitowoc County Sheriff's Department.
And did you recall, or do you recall, ever seeing Sergeant Colburn in the clerk of court's office during the year 2005, your first year in office?
No, I don't think I've ever really seen him ever especially in the inner part of our office, ever.
All right. Are you familiar with an individual by the name of James Link?
Yes, I am.
And who is James Link? That you know?
I believe he's a lieutenant with the Manitowoc County Sheriff's Department.
And again, with respect to the year 2005, your first year in office, do you recall ever seeing Lieutenant Link in your office that year?
There was one occasion in the very beginning of my term. I had contacted the Sheriff's Department regarding questions I had on evidence storage. Because we have a safe that's in my office where we do maintain various kinds of evidence, there's some drugs, and I'm not sure. I think there might be a weapon in there. And going after one of the conferences that I had attended, this was an item of discussion regarding maintaining custody of those types of evidence in our possession. And it was suggested that anytime those types of evidence come into play, that they should be stored at like a sheriff's department or other issuing agency where there's a more secure facility. And I had called Mr. Link, or he was the person I was put in touch with, because he must take care of evidence and things over at the Sheriff's Department. And he had come over to see what was at issue. We discussed it, and we discussed a procedure. And I have been working on a policy and procedure for our evidence retention, and we discussed how we were going to handle transferring that to the Manitowoc County Sheriff's Department.
And approximately when did that discussion occur?
I would say it was early spring. It was probably, very early into that year. So for sure, maybe March or April. I don't think I have anything that really actually documents exactly the date, but it was pretty early in the year.
Other than that one occasion where you had some discussions about the evidence storage policies, other than that, have you ever seen him in the inner office area of the clerk of courts?
Never. I don't think, besides that one incident, I don't think he's ever been inside of our office.
Objection to that form of the answer. If she's never seen him inside the office, she can't say he's never been in the office.
That's her cross-examination. She answered the question as best she could.
Well, I'm going to sustain the objection because of a lack of foundation for the opinion about when she was not in the office.
That's fine. 1 minute. Your Honor, we will pass the witness for cross-examination. However, we would move into evidence exhibits 452 through 457, as well as exhibits 464 and 447 through 451.
All right. I take it that excludes the item that the witness could not identify that was on the screen?
That's right.
But all other exhibits that she testified to, you are asking to be admitted?
Yes.
Mr. Buting.
No objection to those. 452 is the only one that's not.
467 is not offered.
467, I'm sorry.
All right, then all other items that this witness testified to, other than 467, I understand to be offered, and if no objection, they are admitted. Mr. Buting, will you be doing the cross?
Yes, I will, Judge. Thank you. Good morning, Ms. ZIGMUNT.
Good morning.
You became the elected clerk in January of 05. Is this when you took office?
Yes.
So about 10, 11 months before the Teresa Halbach disappearance?
Correct?
Correct. Okay. And would it be fair to state that when you first took office, part of your time was getting used to what the security procedures were and were not?
That's correct.
In existence, and you had some concerns that maybe some of the security and some of the procedures were a little bit, I don't know if lax is the right word, but not as secure as you would ultimately wish they would be them to be, right?
I think that's a pretty good assumption.
Okay. Did you bring the evidence log with you, or the case review log with you?
No, I didn't.
Have you reviewed it before today?
In detail, you mean? Or I guess I haven't paged through and looked for any reason.
Okay, well, for instance, do you know that every person who has come to that office since October of 2005 and asked to look at any file has absolutely, positively been required to sign in on a log?
Since October of 2005, you are saying?
Yes.
That was the directive I have given, and I don't know that it was completely being followed. I think.
Okay.
You know, there were people that were making exceptions for people, but we have tightened up on that
Sure.
to make it.
And as of really, you tightened up as of August 06 is when you really made sure that everybody, all the staff required that people sign in?
I don't have an exact date. I didn't document it for any reason, so I guess I can't say with certainty.
But would it be fair to say that until or around that time, July or August of 06, until that time you would, or I should say at that time you became concerned after talking to some of the staff that maybe some people weren't requiring everybody to sign in and that this was mandatory at this point forward?
Yes, I think my concern was too that they were allowing like attorneys who, if they knew them personally, or like I said, the title insurance companies, things like that. Those are pretty the ones that were allowed not to sign, but I wanted to make it consistent for everyone to have to sign.
Okay, now you were first interviewed by law enforcement officers in this case at the end of December or early January of this, just a couple of months ago, right?
I don't know exactly the date.
Well, did you ever speak to Agent Fassbender or Mr. Wiegert?
Right, they were in on several occasions.
And that was all in the last couple of months or so?
Yeah, pretty much.
So no law enforcement officer came to you in November of 2005 and said, you know, Mr. Avery has been telling everybody that if his blood was found inside Teresa Halbach's vehicle, it must have been planted. Nobody came to you and talked to you about that particular statement, did they?
No.
And between November of 2005 and this past summer of 2006, none of the law enforcement officers came to look at Mr. Avery's 1985 file. None of the investigating law enforcement officers in this case, right?
I can't say that for certainty. I mean, other people wait on people when they are looking
Okay.
at the file, so.
So it's possible that somebody from Manitowoc Sheriff's Department even may have, after Mr. Avery made the public statements that somebody is framing me, somebody has planted my blood, it's possible that somebody from Manitowoc may have come and looked at his file to see if there was any blood in it.
Objection, 2 grounds, speculation, and more importantly, it seems to me we have a limited focus of who may have come and looked from Manitowoc County.
I'm talking about the investigation after the disappearance.
Then I say relevance.
What is the relevance, Mr. Buting?
Let me lay some more foundation questions.
Go ahead.
Let's do it that way. Let me go back a little bit first. As of October of 2005, the 1985 case against Mr. Avery that was in your office was a closed file, right?
Yes.
In fact, it had been not only a closed file, but it was a dismissed closed file, right?
Yes.
So there was no ongoing post-conviction proceedings, right?
Not that I'm aware of.
Or appellate proceedings, right?
I mean, I guess I can't really testify to that. I wasn't really that familiar with the file at that time, so I guess.
Okay, you weren't that familiar with the file, but you do know that the media was asking and other, freelance writers or general public was asking about this file quite a bit.
Yes.
And let me mark a couple of exhibits here. Would it be fair to say that until it was discovered publicly that there was a vial of Mr. Avery's blood in that case file, you weren't aware of it?
That's correct.
And you didn't have any particular concern about the security of that file because you didn't know there was a blood vial in it, for instance, right?
You mean to take any extra security on it?
Right.
Correct.
Okay, and if anything, because there were so many requests to see this file was really kept in a less secure spot within the clerk's office than other old case files would be.
In my office, less secure?
No, the clerk's office, not your office.
Not real. I don't know. I mean, I don't know that it's any less secure. It's pretty secure. It's just not open to the general public.
Sure.
There are very few people who have access.
But you mentioned how it was cumbersome to have to move this big box up and down the stairs, right?
Correct.
Normally is there a vault downstairs or just a room?
Just a room. It's in the basement.
Okay. You have a storage room in the basement where your old files are kept?
Correct.
And Mr. Avery's file, being a 1985 file, would be normally down there in that sort of archive area.
Correct.
But for the fact that once he was exonerated, there were so many demands for it that you left it upstairs in the main area, right?
Correct. And actually, I'm not the one that brought it up originally because I wasn't in the office at that time.
Okay, so it was actually upstairs before you even came into office.
Correct. For possibly 2 years.
Counsel, can we see those exhibits?
Okay, I'm sorry. I'm showing you exhibit 468 and 469. See if you can identify first 468.
Yes, this was the original cardboard box that the file was maintained in.
The file being the Stephen Avery file?
Correct.
1985 file.
Right.
And the one next to it is?
The same file.
Same file from a little bit farther back, right?
Right.
So it was one of your deputy clerks. I'm sorry, one of these. Well, let's publish this so we can talk about it for a minute. This is a picture that shows the file in the clerk's office. This is number 469.
Correct. It was put on the desk that was used for the viewing area, like when attorneys would come in and view the files.
Okay, and you mentioned that it was stored kind of on a filing cabinet next to a window.
Right, which is kind of behind where that divider is.
Let me point to it. Right here. It's right back there, right?
Yeah.
Just over the shoulder of one of your deputies, right?
Correct.
And over here is an old vault, like an actual safe with a whole door.
Right.
We're going to take a break at this time. We'll resume at 10:15. You may be seated, and we'll resume at 10:15. And Miss Butin, you may resume your cross-examination.
Thank you, Judge. Miss ZIGMUNT, I found a digital version of what we were looking at before. I'm going to use that so it will be easier to see, okay?
Okay.
Now, I put up exhibit 469, and the vault that we were talking about, that's the vault door right there, isn't it?
Yes.
I can't read that. It says something safe company. It's very old, 100 years old, probably. Put in when the building was first built, right?
I would believe so.
But it's not something that you use as a locked location anymore.
No.
Wasn't used that way long before you came here, right?
Correct.
Okay. And then over on the other side of Janet's left shoulder is the window that you were referring to, where that box was normally kept until somebody would ask to look into it, right?
Right.
There's a filing cabinet right there, heater, things of that nature.
Right.
Now, the boxes, that is the cardboard box, the way it looked until you had it put into plastic tubs sometime in, you think, July, right?
July of 2006, right.
Okay, well after this photo was taken anyway, right?
Right.
Okay, is that the table that you're referring to? There's like a desk or a table that it can be put on when someone asks to see it, if they can go through.
Correct. That is where they originally used to look at files. I mean, and that one too. But just with that file being so cumbersome and so many exhibits involved, there's really not a place to spread it out. And it just wasn't a real good location. There's a lot of traffic through that area from the back room off into the section where you see the other clerk sitting there. People traveling back and forth all the time. It just didn't seem a real secure place with all the exhibits and all that paper out.
Sure. And the file actually was the exhibits in it as well as the paper documents, right?
Correct. All the exhibits are underneath all of it. I think all the paper was pretty much at the top.
Right. And this particular file has things like clothing and whatever was introduced as exhibits, just kind of like what we have in this case today.
Correct.
But I want to draw your attention to, there's a partition right here on the far right side of the picture, right? Some like notices posted.
Right behind the box.
Right behind the box, yeah. And so the way it's set, it's not a partition that goes all the way to the ceiling, but it's not the same height as that. The partition in the background there.
Correct.
There's a number of partitions like that in the clerk's office within the interior part of the clerk's office.
Yes.
And so when one is standing there like Janet is by this box, the people on the other side of the partition don't see that box.
Correct.
And other than this one woman in the background here with the long blonde hair, there's no other clerk desk in that back area.
Correct.
So I don't have a schematic of the layout, but the way this works is this is sort of a narrow hallway that leads to this area right from one of the doors that goes to the public area, right?
Right.
And then behind the partition over here is where the main area where all the clerks work.
Right. There's like a separate area over there. There's, I think, 5, including the one with the blonde hair, different workstations that are set up.
Okay, so if the clerk who works in that particular workstation is not sitting there right then, when someone is going through this file, you could go through this file without the rest of the clerks directly seeing you moving things around in the box, right?
Correct.
And your deputy clerks, like both of the individuals in this picture, have a lot of duties. They move to and fro during the day, right?
Correct.
So the woman in the back, I suppose we could give her a name, but the woman in the background of this photo is not sitting in that chair all day long while she works.
Correct.
Okay, now the cardboard box that we were looking at, Exhibit 468, has the pleadings and docket minutes, at least in this instance, they're sitting right on top, right?
Right.
So it wouldn't be very difficult for someone to know that this particular file or box is in Steve and Avery case, would it?
I guess if you looked at it, you would have to, in that condition of the box, that one day, and when people go through it, it doesn't necessarily end up back in that same condition. And I think when it was kept over on the side filing cabinet, I tried to level things out so the cover and the flaps could come over, because I didn't think that was very secure.
Sure, but there's that. See that foam board exhibit on the background?
Right, and that would probably stick out no matter where.
Yes.
Because it was too big for the box.
So the box wouldn't close.
Right.
Okay, no matter what you did. All right. Now, would it be fair to say that the presence of sheriffs and deputies inside the interior part of that clerk's office, it's not that unusual an event, right, in the normal course of your business?
To have sheriff deputies in our office?
Objection. Relevance as asked.
Well, it's entirely relevant.
What is the objection?
Relevance as to the phrasing of that particular question vis-a-vis the pretrial court rules.
Well, it could be laid as a foundational question, so I'll allow it for that purpose.
Thank you. Do you understand my question?
If you would like to just repeat it.
Sure, okay. You know that door that you showed us, the photograph that has the little, lock combination?
Yes.
When you go through that door, you go into the inner office of the clerk's office, right?
Yes.
And in that area, it's not unusual to see sheriff's deputies during the normal course of business, is it?
The only sheriff's deputies that would normally be in our office would be probably the sheriff's bailiff that are posted in the courthouse for security reasons. And they
right?
Go occasionally.
In fact, they are in there every day picking up files or returning files from court, right?
Yeah, they are in there frequently.
Okay. And similarly, drug unit officers are assigned to drug units at various times, are back in that area because they're dealing with search warrants and filing and returns and all of that as well, right?
They could have access. I mean, they don't have access. They don't have the code to get in. They would have to be buzzed in.
I'm sorry. My question is whether it's unusual to see them in that area. Wouldn't it be an unusual event to take note of
Correct.
in your mind, right?
Correct.
And that would be true of your deputy clerks as well, right? Maybe more so than you even.
True of the deputy clerks. What do you mean?
Seeing a
That they would see them?
Seeing a sheriff's department employee in that area was not such an unusual event that it would make someone take note in their mind, hey, what's going on here? Would it?
Correct.
Speculation, foundation for this witness. Ask the answer to be stricken.
No, I will allow it.
And on occasion, even sheriff's employees may be coming into the interior of the office, like attorneys going through files while they're investigating an old file. I'm sorry, looking at an old file in the course of their investigation in a new case, right?
So your question is an attorney?
No, badly phrased. Let me retry it. Sheriff's employees, sheriff's deputies, also on occasion are in that back area, the inner area of your clerk's office, looking at one case file, perhaps as part of their investigation on somebody in another case, right?
I guess I can't really say. I don't know that they would be looking at a file there. I mean, if anybody requests to look at a file, it's usually done over the counter. I don't know that it's,
All right, but you don't.
I mean, right. I can't say with 100% certainty what they are doing because you're usually dealing with the deputy clerks like of a specific unit.
That's right. And you are usually back in your office and they're dealing with a number of different clerks, deputy clerks.
Correct.
Now, in addition, the sheriff's department has access to the clerk's office with master keys. Isn't that right?
The security bailiffs would.
Okay. Do you know a list? Oh, do you know well, let me go back for a second. Do you know that the sheriff's department is responsible for the security of the whole courthouse facility?
Yes.
And that if there's a fire or something after hours, they have to have access, right?
Yes.
Both to the courthouse and to all of the rooms within the courthouse, right?
Yes.
And there are a number of master keys that are issued by somebody from Manitowoc County to give to people who are allowed to have this kind of access, right?
I would imagine. I don't know specifically.
Sure. You don't know who, but you know generally that's the case, right?
Yes.
If you have a master key to get through that doorway, you don't need the separate combination lock, right?
I wasn't aware of that before, but during the investigation, when the keys were, when it was being questioned, it did come to my knowledge that the key could be used to gain access to that door.
Sure, the whole idea of a master key, it wouldn't do much good if they turned the lock, but then you couldn't get past because you got to have the combination, right?
Correct.
So the way it was set up, at least the way it was set up in the fall of 2005, was a master key wouldn't allow entry into the inner part of the clerk's office.
I guess so.
Okay, and that would include after hours on weekends or in the evenings, right?
Correct.
Okay, now Mr. Fallon asked you on direct if you recalled seeing Sergeant Colburn or Lieutenant Link at the inner area of the clerk's office. Do you recall that question?
Yes.
That question was never put to you until sometime in late December or early January 2006, and 2007, correct?
I believe that's probably correct.
Okay, so nobody asked you about whether you could recall seeing Lieutenant Link or Sergeant Colburn until about 14 or 15 months after the Teresa Halbach disappearance, right?
I guess, yes.
Okay, so between November of 2005 and December of 2006, no investigating officers in this case came to you and said, hey, has anybody come to look at the 1985 court file? Right?
I don't think so. I think it was pretty much just when all the investigation was going on, like you said, late November, December.
Well, let's get clear here because your answer isn't, I'm sorry. All the investigation going on you're talking about is all the investigation that started once the blood vial was discovered there, right?
Right. I believe when the special investigator that was assigned.
Mr. Fassbender.
Right.
Okay.
I guess I don't have a specific date though. I mean, I didn't mark it down for any reason, so.
We're talking generally here, okay? I'm going to get to some pictures with you in just a minute. But after the defense filed a motion in December, someone in your office took that white box that we looked at from the exhibit out of the court file and locked it in a safe for security, right?
I believe it was done pursuant to an order of the court.
And that was in December of 2006, right?
Okay.
Okay. Do you agree?
I agree. I don't have certainty. I mean to the time frame. It would be the approximate time.
Okay.
But I don't have anything to verify that.
Sure. And shortly thereafter, a week or so later, the attorneys all came to your office and we, with the court's permission, opened that safe and opened the box. Do you recall that?
Correct.
And do you recall we videotaped it and took photographs?
Yes.
Sort of at various stages, right?
Yes.
Okay. Bear with me just 1 second. I'm going to play an excerpt of that videotape. I think counsel has no objection.
Not as long as it's played as represented.
Sure, no audio.
As represented, no audio will stipulate to the fact that counsel indicated that it's a 10-minute version of a 33-minute event. Is it marked as an exhibit?
We'll mark it right after this. I'm going to have it marked as an exhibit.
Very well.
If you want to reserve the next number, this will be a DVD of excerpts of. Just so we're clear, you recall the date was December 14 of 2006.
Yes.
Okay. And what I would like you to do is to watch this and then just tell us afterwards if this, in fact, comports with your recollection of what this box and its contents look like at various stages as it's opened. Okay? Now stop for 1 second. At this point, this is a closer up version of one of the exhibits that you have in front of you, Exhibit 451. This shows the end of the box secured as it was when we looked at it on December 14th, right?
Correct.
And from this, you can tell, I mean, you're familiar with the way the exhibits are typically sealed with red evidence tape or white evidence tape or whatever, right?
Correct.
And it's pretty clear to you, even at this stage, that the evidence tape seal had been opened and the box reclosed just with that little piece of Scotch tape, correct?
Correct.
All right, let's go on. We're looking at the handwriting that was on the outside of the box that you referred to earlier.
Correct.
And this is actually taking place in your personal office, right?
Right.
There's a label with the date of January 4th, 1996.
Yes.
Is that Mr. Wiegert there putting on some gloves?
Yes.
And just so the jury is clear, you earlier referred to this whole container as a styrofoam box, but it's a cardboard box that contains a styrofoam box within it, correct?
That's correct.
And as we see it right now, that evidence seal on the card on the inner styrofoam box appears to be secure from this angle, right?
Yes.
Now, Mr. Wiegert is removing the styrofoam box, and we're getting a close-up view of the other side of the styrofoam box, and that seal appears to be open, does it not?
I believe so.
Could I make an observation? It might be best to let the exhibit speak for itself. I think further viewing will establish several points.
The court agrees. I don't believe the witness has any specialised knowledge in this regard. Mr. Butin, if at any point you want to stop the tape and point something out to the jury that's on there, you may.
Okay, thank you, Judge. Now, just so we're clear, you were actually in your office as we were doing this as well, right?
Yes.
So you saw us videotaping this.
Yes.
Okay, keep going. The parties are sort of rocking this gently, this tube of blood back and forth, gently. Were you able to determine if it looked liquid inside there from where you were at?
I couldn't see it from where I was.
Just so the record is clear, there is no kind of evidence seal or tape around the top, the lavender top to that tube, is there?
It didn't look like there was.
Okay. All right, so does that video excerpt of the events of December 14, 2006 purport with your recollection of what happened when we opened that box?
Yes.
Thank you. I have no further questions. We'll mark this as an exhibit.
And the number of that exhibit is?
470.
And that's a DVD of what we just viewed in court.
Correct. Mr. Fallon, any redirect?
Just one moment. I might have a question or two. To your knowledge, Ms. ZIGMUNT, the only sheriff's deputies that have a key that permits access to the inner office of the clerk of courts are the 2 bailiffs?
Objection. Calls for speculation, unless she knows.
The question should be preceded by a foundational question to determine if she knows.
Let's go about it this way. In your cross-examination, you were asked it was not usual to have sheriff's deputies in the inner office area, and you responded yes, just the bailiffs. Explain why you answered in that regard.
Because the bailiffs are pretty commonly seen in the office. They come and go with different reports and different things during the day. Sometimes they are in the office before I get there in the morning. I'm usually one of the first people in the office, and one of them might be in the office delivering or picking up. They have a pickup place for papers every day, so it's not uncommon to see them at any time, really.
All right. And do they have a key that permits access to the inner offices?
They must have a key. I mean, I guess I really never looked to see if they were using the code, and they would have to have a key because if they got there before I do, you would need a key to get in the outside door of the office.
Are they permitted the cipher lock code as well?
I know we changed the codes because I changed it like January of 2006. We changed to a new code from the previous clerk of court just for some security measures, and I did provide them with that access code at that time.
Now, to your knowledge, did you provide that access code to any other member of the sheriff's department other than the bailiffs?
No.
And I believe you also answered a question on cross-examination that perhaps on occasion other deputies are in the inner office area from time to time. Did I understand that correctly?
There could be someone that had business with one of the clerks. They would have to be buzzed in. They wouldn't have automatic access. Someone would have to allow them. Like that doorbell little device thing, we have some of those under the desk at the counter clerks have those, and they press that to open the door for.
So do I understand it correctly then that they would be buzzed in and they would be attended to by one of your clerks?
Right. If they had, I mean, a lot of times too, if they come in, I mean, we take care of them over the counter. I mean, I don't really know what the different business is that they would have to come in for, but occasionally they would ask, like if they asked to see Janet or something, and then if someone determined that she is there, they would buzz them in, and they could just go to her desk.
That's all we have. Thank you.
Anything else, Mr. Buting?
Just very quick. You mentioned how if they would ask to see Janet or some other deputy, they would be buzzed in, and then the sheriff's department employee would then be in the inner area, right?
Right. I mean, I don't know specifically that any sheriff's department.
I understand that. I'm just saying, just general common practice would be if one of the sheriff's officers, employees, lieutenants, whoever, asked to see somebody, they would be buzzed in and they could go in back and talk to the clerk or deputy clerk or whomever, correct?
Correct.
And then once back in that area, they would have had in, let's say in October, November 2005, they would have been in the area where Mr. Avery's file could be accessed, right?
Well, going to Janet's area would not. I mean, they would be turning the corner right away. Where his file was kept was straight ahead and a little out of the way. So I don't think that they would have
Well, there's no
come in contact with that file at all.
there was no other door in between there they would be and where Mr. Avery's file was kept, right?
There was quite a distance from it.
Well, we saw on the photograph approximately.
Well, that was when it was on the desk, though, in the desk for the viewing area. That isn't where it was normally kept. It was kept on a filing cabinet, although further away yet. So it was really
10 feet from the door, maybe 15 feet.
maybe 20 feet from the door.
Okay, all right.
25, I don't know.
Sure. The point being, though, once you get past that door where you're buzzed in, it's all open with partitions in the inner area of the clerk's office.
Right.
And I'm not trying to put blame on you, ma'am, but I understand that in November of 2005, it was not on your radar. You were not worried about an officer from the sheriff's department coming in and removing a court exhibit to plant evidence and frame somebody, was it?
Objection beyond the scope.
Sustained.
That's all.
All right, the witness is excused, and members of the jury will take a stretch break before the state calls its next witness. All right, we'll take a short break, 5 minutes, and then we'll come back. You may be seated.
Thank you, Judge. As we alerted the court before the start of today's proceeding, the state does anticipate calling Dr. MARC LEBEAU to testify. Mr. Buting was kind enough on cross-examination to have showed the jury the blood vial, purple-topped blood vial tube, which the state believes entitles us to call Dr. LEBEAU at this time. We had assured the defense that Investigator Wiegert was going to testify, and he is, but that's just as to the packaging of the purple-top blood vial and sending it to Dr. LEBEAU. We would prefer to call Dr. LEBEAU so that his direct examination and his cross-examination can be completed before he goes back to Virginia today. If the defense still wishes us to call Investigator Wiegert at this time, we had also assured the defense and the court that we would recall him neither for cross-examination or continued cross on matters outside of the limited purpose of packaging the blood. So we're just looking for direction from the court. We would prefer, since the vial has already been shown to the jury, to start with the Dr. LEBEAU and complete his testimony and then call Investigator Wiegert. And if there's other foundational witnesses, that may be necessary. If there's an issue, or if the court believes that somehow to be an inappropriate use of resources or the presentation of evidence, then we can certainly do it the other way as well.
Mr. Buting,
Could I have just one moment with counsel, please?
go ahead.
Judge, we can defer Investigator Wiegert's testimony until after Mr. LEBEAU, but I'm marking 4 other exhibits which are essentially hard copies of what we just saw. And by stipulation, I was going to use Investigator Wiegert to introduce those, but we can just by stipulation, introduce them and proceed with Mr. LEBEAU if that's what council prefers.
That's fine. 471, start with Janet.
Yes.
And then I will be moving all the exhibits that I introduced, which is 466, 468. Well, let's let her mark them first. Okay, so it will be 468 through 474. Is that all right, council?
Just so I can see them.
Okay, so then I would move 468 through 474.
Is that a different photo than 451? Janet, can you look at 451 and see if 474 is different?
Let's go off the record for a couple of minutes here. Council, are you ready to go back?
I am. Mr. Gahn is still checking something for me.
Alright, I believe that we'll go back on the record at this time. Additional exhibits have been marked. Those are numbers what?
471 through 474.
471 through 474? Are the parties asking that they be admitted at this time?
468 through 471 actually is what I'm asking to be moved.
468 through 471?
Yes.
Any objection from the state?
They are eventually going to get in, Judge. We have no objection at this time.
Alright, those are admitted. Anything else before we bring the jurors back in?
No.
If not, we'll bring the jury back in at this time. You may be seated. At this time, the state may call its next witness.
Yes, Your Honor. The state would call Dr. MARC LEBEAU to the stand.
Very well.
Please be seated. Please state your name and spell your last name for the record.
My name is MARC, M-A-R-C, LEBEAU, L-E-B-E-A-U.
And what is your occupation?
I'm the unit chief of the chemistry unit at the FBI laboratory
And where is the FBI laboratory located?
in Quantico, Virginia.
And how long have you been so employed?
I have worked as a unit chief since September of 2000. And prior to that, I was within the same unit at the FBI laboratory, the chemistry unit, since 1994.
And what are your duties at the FBI laboratory in the chemistry division?
Well, as the unit chief, I oversee the day-to-day operation of that unit. That entails making decisions about the types of cases that we accept into our unit for analysis, and then assign those cases to the most experienced or the appropriate personnel that work under me. When we receive evidence into our unit, we're typically asked to analyze for the presence of a chemical, whether or not is it in or on a piece of evidence. Then we compile our results and prepare a report. And before that report is released to the contributing agency, another duty of mine is to review the result and the report to make sure that it meets all of the quality requirements that are set forth by our quality assurance department in our laboratory.
And what is your educational background, doctor?
Well, I have a bachelor's degree in chemistry as well as a criminal justice from Central Missouri State University in Warrensburg, Missouri. I also have a master's degree in forensic science from the University of New Haven, and that's in West Haven, Connecticut, and a doctorate in toxicology from St. Louis University from the University of Maryland in Baltimore. I took an additional 4 years of graduate level coursework at St. Louis University in the early 90s.
Now, when you say you have a doctorate, is that what is commonly referred to as having a PhD?
Yes, it is.
And thus titled Dr. MARC LEBEAU.
That's correct.
Would you describe any experience or special training you had in your field?
Yes. Well, when I started with the FBI laboratory, I was thoroughly trained in the types of examinations that we typically do in our laboratory. These are examinations specifically in the area of forensic chemistry as well as forensic toxicology. Before I started with the FBI, I worked at as the laboratory manager of the St. Louis County Medical Examiner's Office in St. Louis. And I did that for about 4 years. Excuse me. I have also worked as a chemistry instructor at the University of New Haven, as well as a laboratory intern at a private toxicology laboratory in Willow Grove, Pennsylvania, called National Medical Services. And I have also worked as a laboratory technician for Monsanto Chemical Company.
Do you belong to any professional or scientific organizations pertaining to your field?
Yes, I do.
And will you describe for the jurors what those are?
Yes, I'm an active member of the Society of Forensic Toxicologists, and I serve on their board of directors, as well as I chair one of their committees. I'm also involved with a member of the International Association of Forensic Toxicologists. And again, I serve on two committees within that organization. And I'm an active member of the American Academy of Forensic Sciences. And I hold a membership level of fellow within that organization, which is one of the highest membership levels that you can have.
And do you attend conferences within your field for forensic purposes?
Yes, I do.
And how often and why?
Well, I attended the conferences of those three organizations pretty much annually, specifically to stay on top of the current trends within our field of forensic chemistry and forensic toxicology. But I also am often invited to put on workshops and be a guest speaker at a number of conferences.
Is your lab at the FBI an accredited lab?
Yes, it is.
And what does it mean to be accredited?
An accredited laboratory simply means that a body of experts that will from time to time come into the laboratory and check our practices to ensure that you're following a set of standards that this body has set down to those that they accredit. So it's simply a quality measure so that we have consistency from one laboratory to the next. When you're dealing with an accredited laboratory under the body that accredits the FBI laboratory, which is known as the American Society of Crime Laboratory Directors Laboratory Accreditation Board, or ASCLD Lab, all laboratories that are accredited by that agency will follow their same standards.
Do you undergo proficiency testing?
Yes, we're required to as part of our accreditation.
And what is proficiency testing?
Proficiency testing is simply we're provided the test cases from time to time where we're asked where we don't know the results. Some outside entity knows the results, and we analyze these test cases as if they were real cases and then provide those results to the referee, if you will, of those results. And they grade our results and then report back, not just to us, but they report our results back to our accrediting body as well.
And how have you done on your proficiency test?
I have passed all of the proficiencies I have taken in the 16 years I've been employed in this business.
Have you ever tested as an expert before in court? Testify. Let me repeat that. Sorry. Line 9. 3, 2, 1. Have you ever testified as an expert before in court?
Yes, I have.
How many times?
Well, approximately 40 to 50 times.
Have you ever been rejected as an expert in your field?
No, I have not.
Have you co-authored or co-authored any peer-reviewed journal articles?
Yes, I have.
And could you describe some of those to the jurors?
Well, I have authored or co-authored about 15 to 20 peer-reviewed journal articles, professional articles, scientific articles that are published in professional publications.
And I have had placed in front of you an exhibit that was marked as Exhibit 433. Could you tell the jurors what that is?
Yes, this is a copy of my curriculum vitae, essentially my resume that describes my experience.
Now, did you analyze samples that were sent to you in this case?
Yes, I did.
Describe how you and your lab became involved in this case.
Well, following the normal course of business at our laboratory, as the unit chief, as I indicated, I am the gatekeeper, if you will, of cases that we accept to work. And I was contacted by the local district attorney's office to make a determination whether or not we could provide assistance in analysis of specific evidence in this particular case.
And did you know that this was a case that involved an allegation of police planting evidence?
Yes, I did.
Why would a case such as that, an allegation of law enforcement officers planting evidence, be of a concern to the FBI?
Well, one of the areas that the FBI is responsible for investigating in this country is crimes of public corruption. This is where a politician or another public official, such as a police officer, is accused or believed to be involved in doing something illegal. So that is an area that we are strongly involved in our investigations at our agency. And of course, that's a very serious allegation. If an individual is truly in that political position or in a law enforcement position and they're doing something illegal that erodes the public's trust in that agency or that individual, and we would want that certainly that individual out of that office or off the street. But additionally, if they're being wrongly accused, we want to be involved in that investigation to help set the record straight and hopefully clear their name if they're wrongly accused. So again, the trust can be restored.
And did the testing that you performed in this case determine that issue?
I believe it did, yes.
Before we get to your conclusions, I would ask you to describe for the jurors basically what type of instrumentation did you use to perform the testing in this case?
Well, we used an instrument that's called a liquid chromatograph mass spectrometer, and we abbreviate that as LCMS. And then we also took that one step further and did additional experiments with a mass spectrometer. That the entire technique is what is known as LCMS-MS. It's essentially 3 different instruments, if you will, that are all linked together and handshaking with each other so they work in tandem.
Would you describe for the jurors exactly what analytical chemistry is?
Well, analytical chemistry is a subset of the whole field of chemistry that, in a nutshell, just is trying to determine the chemical properties or identify of matter. A little simpler put, analytical chemistry involves trying to either identify the present or the chemical characteristics or the identity of an unknown substance, trying to figure it out what it is. Or if there's an idea that there's a specific chemical in some material, then we will target that analysis in trying to figure out if a specific chemical is present in that substance.
And this instrumentation that you have just referred to, the LCMS-MS, is that what you used in analytical chemistry to determine these chemical compounds?
Yeah, it's one of those tools that we use in order to do just that, identify what the substance is, or to target a particular analysis to see if specific chemicals are in material.
Could you very briefly and as simply as possible tell the jurors how this instrument works?
I will try. It's again, it's 3 instruments that we're really talking about. The most simple form is to talk about is as 2, the LC portion and the mass spec portion. The liquid chromatograph, or LC, its job is simply to take a mixture of chemicals and separate them so they're delivered to the next instrument, the mass spectrometer, one at a time. And a good analogy to think of is if we had a bag full of marbles and we knew that some marbles were real small, other marbles were of a medium size, and the remaining marbles were very large. And we can even complicate it a little more by saying that the large marbles of 2 colors, some are blue and some are green. If we were to put these marbles, thinking that they are chemicals, into our liquid chromatograph, the LC portion, it would take that mixture and separate them so then when they came out of the instrument, the small marbles would come out first, say 1 minute after they were introduced. The medium marbles would come out maybe at 2 minutes after they were introduced. The large marbles would come out, or I should say the large blue marbles perhaps, would come out at 3 minutes, and the green marbles would come out perhaps 15 seconds later. So it allows that mixture to be separated into the individual components so that the next instrument only sees essentially one chemical at a time. And that's important because the next instrument is that mass spectrometer. And what it does is it gives us the fingerprint of that chemical, breaks it apart into small pieces using a very large amount of energy, breaks it apart, and presents us a fingerprint that we can then compare. And essentially, all chemicals give you a different fingerprint. That's the value of a mass spectrometer. It gives us information about the weight of the chemical as well as its fragmentation pattern that then will interpret using a set of guidelines in order to determine if it matches the specific chemical we're looking for, or if we're trying to figure out what unknown chemical it is, we can match it against the database to see what it matches.
And how long has this technology been around?
Well, LCMS has been around for decades in analytical chemistry laboratories.
So is this a standard instrument used in analytical chemistry?
It is. We use it in our laboratories since the early 90s.
Is this technology used in other fields besides analytical chemistry?
Yes, it is.
Could you describe a few of those for the jurors?
Well, LCMS is very widely used in the pharmaceutical industry when they're developing new drugs. They're looking for new metabolites of drugs and trying to identify what those are. It's also used in looking at explosive residues. If a bomb is discharged, it can look for the residues of the explosive portion that caused that. It's used to test athletes for steroids. It's used to test workers for whether or not they're smoking marijuana on the weekends. It's also used in the food industry to look at various components in food. It is used in agricultural chemistry as well.
I would like to switch topics a little bit now and ask you, would you explain to the jurors what EDTA is?
Yes, EDTA stands for ethylene diaminide tetracyclic acid. And EDTA is simply a chemical that is known as a chelating agent. And what that means is it simply will take metals that are in the environment of this chemical and latch onto them, bind to it, and remove them from that environment that it's in.
Where is EDTA found?
EDTA is found in a lot of commercial products that we all use. It's found in your shampoo. It's found in your laundry detergent. It's found in a number of foods such as sodas. And it's found in fertilizers, just to name some. And the reason that they're in things like detergents and shampoos is that it attaches to metals. And I don't know if you have heard hard water here in this part of Wisconsin, but generally hard water has a whole lot of metal in it. That's what makes it hard. So what that shampoo will do with the EDTA in it is latch onto those metals so that it actually does a better job of cleaning. Same with your detergent. So that's what EDTA is found in, a whole lot of different commercial products.
And what's its purpose? Again, what is it used for?
To bind metals specifically, what it is used for is a chelating agent. And then, as I indicated, because of that binding of metals and different uses, it helps stabilize certain food products, for example. So that's why it's used. In that instance, it might be used in a laboratory setting to serve as a buffer in a reagent.
You use the word, it's used as a stabilized something. Could you explain a little bit more to the jurors what you mean by a stable chemical?
Well, a stable chemical is one that doesn't easily break apart. That's a very simple way of explaining it. It's very rugged. It's not fragile.
Are there studies in the scientific literature or articles about the stability of EDTA?
Yes, they are. There are numerous studies in this scientific literature that talk about the stability of EDTA.
And why would these studies be made?
Well, most of the studies that have been done in the past few decades are studies that are concerned with the prevalence of EDTA in the environment. As I mentioned, it's stable and it attaches to metals. And over the years, as the use of EDTA continues to be used in more and more products, what we're seeing in the environment is that it continues to build up because EDTA is so stable. So we're finding it in wastewater and river water, find it in your soil. And what the concern is, of course, it's taking metals out of your water, taking metals out of the soil that are normally supposed to be there for the normal process of biology and latching onto them, making them unstable in their normal form. So that's what most of the studies are talking about, the stability of EDTA in the environment and the concern of it building up over time, and the difficulties of actually removing it from the environment out of your water before you drink it and out of soil, etc.
These articles or other studies, these were studies that were developed by other scientists. Is that correct?
Yes, scientists from all over the world. These publications are from the Netherlands, from South America, from the United States, all over Europe. Yeah, essentially all over the world.
Would you tell the jury a little bit about your experience with the stability of EDTA?
Well, as part of work that we did around this case, is we were interested to see whether or not blood that was in an EDTA tube and put onto a spot card, which is simply a card that you put a spot of blood on, if that were stored at normal room temperature environment for a number of years, would that EDTA remain in that blood stain? And we did find that a stain that was made in May of 2004, today still were able to detect the presence of EDTA in it.
So this chemical is not easily broken apart under normal environmental conditions. Is that fair to say?
That is absolutely a correct statement.
And why not?
Well, again, it is not a fragile chemical. It is not fragile at all. It takes very severe conditions to break it down. For example, it can withstand temperatures up to 300 degrees Fahrenheit before it will break apart.
And this chemical, EDTA, is this chemical that you could test for its presence in the substances in this instrument that you talked about at the FBI?
Yes, absolutely.
Now, I would like to ask you, Doctor, what is a blood collection tube?
Well, a blood collection tube is simply the glass test tube, if you will. Then when you have blood drawn at a doctor's office, it is the tube that they put your blood in.
Are there different kinds of blood collection tubes?
Yes, there are.
And would you be able to describe those for the jurors?
Yes, I could.
You have prepared a PowerPoint presentation to give this description. Would that be helpful to the jurors while testifying?
Yes, it would.
Do you have a mechanism to back this up? I think we want a different slide initially to start with the collection tubes. And again, I'm going to ask you could you describe a little bit more about these different types before we get the slide set up? These different types of collection tubes, why they have different types?
Well, there are a number of different types of tubes. One type of tube has nothing in it. It's simply your blood goes into the tube and it's there with nothing added to it. But the majority of collection tubes that we deal with have some form of preservative or an anticoagulant in that tube. And the reason being is that you want to allow this blood to be stored for some time so it's still usable to the laboratory. As I indicated, there are multiple types of tubes, and the way we can tell what is in the tube is simply by the color of the stopper on that tube. The color indicates what's inside the tube before it gets filled with blood. So the red stopper tube, as you can see on the screen, has nothing in it, whereas the yellow stopper tube has citric acid or citrate in it. The gray stopper tube has sodium fluoride and potassium oxalate in that one. And then the lavender or purple stopper tube has this chemical EDTA. Now, when the blood is put into these tubes, you shake them up so that the chemical additive is well mixed within the tube, and then it does its thing. Now, if we start by looking simply at the red stopper tube with nothing in it, what happens is within our blood, we have blood cells, red blood cells, which I'm sure, heard of, but we also have calcium in our blood. And that's important because the calcium plays a very key role in those red blood cells staying apart from one another. After a while, if we don't have a preservative or an anticoagulant in that tube, what happens is those red blood cells clot. They come together and form clots within the tube, which of course makes it very difficult for laboratories to do testing on the blood. So that's why we use these anticoagulants and preservatives in these tubes. If you look at the purple stopper tube, which is your EDTA tube, the EDTA is within the blood, mixed in with the calcium and the red blood cells. And as I said earlier, the role that EDTA plays is to bind metals such as calcium, but it binds any metals that are present in our blood. And a lot of those metals come from our diet, from our normal metabolic processes that occur in our body. So the EDTA is going to bind with those the calcium, the iron, and other metals, and again, latch onto it and make it unavailable for its normal use. So that's going to prevent your blood from clotting. And that's why EDTA is in the purple stopper tube. What this does, as I said, we have iron floating around in our blood, and we have calcium, which is the Ca, iron is Fe. The EDTA comes along and it complexes with those metals, complexes with the calcium, and it complexes with the iron. And that's simply what the different blood collection tubes are, and why EDTA in particular is present in these purple stopper tubes.
And when you did your personal stability test for EDTA, was it blood stains from a purple topped tubes?
That's what was reported to us. I'm sorry, what was your question?
When you did your stability study and degradation study, was it blood stains from purple top tubes?
Yes, they were. They were all stains that were generated from purple stopper tubes. These were generated again in May of 2004, and we analyzed them just last week.
And the chemical that you would be looking for, just so we're clear for the jurors, in the instrumentation that you have described, again, according to this slide, what can you identify with your instrumentation?
Well, we specifically focused on EDTA bound to iron as well as free EDTA. There's so much EDTA in that tube that not all of it is used. In fact, the majority of it is not used. So there's a lot of the original EDTA still floating around, unbound to anything. So we focused on both the unbound EDTA, the original form, as well as the EDTA that was bound to iron. And we chose the iron over calcium simply because iron is about 10 to 30 times more abundant in our blood than is calcium. So it would make it easier to answer the question that was put before us.
And did you receive samples to test in this case?
Yes, we did.
And do you recall what did you receive?
We received a number of swabs that were reported to us as having been taken stains out of a Toyota RAV4, as well as control swabs that were collected in these areas near where those bloodstains were. And we also received a tube of blood in a purple stopper tube, EDTA tube, that was collected from Mr. Stephen Avery.
I'm going to ask Agent Fassbender to bring you what had previously been marked as Exhibits 332, 334, and 336. Dr. LEBEAU, would you look at Exhibit 332, which has been already entered into evidence and testified to by Charee Culhane as being a blood swab that she took from the dashboard of Teresa Halbach's RAV4, and she identified that as her laboratory number A-8. Did you receive that?
I'm sorry, could you repeat the exhibit number?
Exhibit number 332.
And A?
It was previously identified by Charee Culhane from the State Crime Lab.
Why don't we just read what's on the exhibit?
This says A10.
I'm sorry. Then I'm asking you to look for the one that is for A8.
A8 has exhibit 336 on it.
And that was previously identified by Charee Culhane as a bloodstain taken from the dashboard of Teresa Halbach's RAV4. Did you receive that?
Yes, I did.
And how can you tell?
I can recognize our laboratory number that we placed on this packaging, as well as the initials of the technician that did perform the analysis, and my own initials.
Okay. And did you test the swabs from that bloodstain using the technology you have described to the jurors?
Yes, we did.
Now, I would ask you to identify for us, if you can, what would you have been marked as A12, a blood stain from the rear passenger door of Teresa Halbach's car.
That's correct.
What exhibit number is that, please?
Exhibit 334, yes.
And again, that has been already entered into evidence and identified by Charee Culhane as a blood stain.
Your Honor, I would object to counsel telling this witness what has describing these exhibits as something other than what this witness knows. This witness should testify to what he saw, what he was advised, but what was testified to, he has no knowledge of.
I agree that I don't know that this witness was in a position to say what a previous witness said. But if these exhibits have been admitted on that basis previously, I think it is help for the identification. If there's a dispute about that, then I think we should be heard. Is there a question?
Not at this time. You can proceed.
All right.
And again, Exhibit 334, did you receive that for testing in your lab?
Yes, we did.
And how can you tell, Doctor?
Again, our laboratory number and the initials of both the technician that did the work as well as myself.
And would you have Exhibit 336 there?
Yes, I do.
And that is an exhibit that has been previously identified by Charee Culhane from the State Crime Lab as a blood stain that she took from a CD case from Teresa Halbach's RAV4. Is that correct?
No, sir.
I'm sorry. 332, is that correct?
Exhibit 332 is identified by the label on the packaging as being collected from the CD case on the front passenger seat.
And did you receive that for testing?
Yes, we did.
And how can you tell?
Again, our laboratory number written on the packaging as well as the initials of the technician that did the work and myself.
I'm going to ask Agent Fassbender to bring you 3 additional envelopes, which were control swabs taken in this case. And again, Dr. LEBEAU, just the last exhibit, 332, is that marked as exhibit have identifying cryo lab number A10?
That's correct.
Dr. LEBEAU, would you look at exhibit 476?
Yes.
And can you identify that exhibit?
This is reported to be a control swab or 2 control swabs that were collected from the rear passenger door in the RAV4.
And did you examine those?
Yes, we did.
And how can you tell?
Again, our laboratory number is placed on there as well as our initials.
And would you look at exhibit 475? Can you identify that exhibit?
Yes, I can.
Will you tell the jurors what that is?
This is reported to be control swabs that were collected from the RAV4 off of a CD case.
And did you receive that for testing?
Yes, we did.
And how can you tell?
Again, the laboratory number that we assigned to this case as well as our initials are on it.
And do you have exhibit 477 in front of you, sir?
Yes, I do.
And can you tell the jurors what that is?
Again, this is reported to be control swabs that were collected from the RAV4 in the ignition switch area of the vehicle.
And did you test that with the technology that you have described?
Yes, I did.
Objection, Your Honor. I think we need, for foundation purpose, when he says, did you test, counsel is asking, did you test this? Did you test that? And he is repeatedly answering, we tested. Yes, we did. So I think there needs to be some clarification as to what this witness did.
The court agrees. That should be clarified.
Would you explain when I say, did you test this, I'm talking about the FBI. Would you explain to the jurors when you receive evidence how the testing process proceeds?
Technically, the way we're set up is certainly the manager of the unit doesn't have a lot of time to spend performing the actual analysis. So we have 2 levels of scientists within our unit. We have what are called chemists, which are essentially technicians, but they're well-educated technicians, many with PhDs. And then we have examiners, and in this role, I serve as an examiner. The examiner is assigned to the case and oversees the analytical work that's done on the case. So they're the supervisor. They're in the close contact with the technician that works on the case, oftentimes in the lab with him, helping out. But most of the analytical work is actually done by a qualified chemist. When the work is finished, the analytical product, the results, are handed off to the examiner who compiles the results, forms the opinion that is then put into the report, as I indicated earlier, and is sent out to the contributing agency. So it's simply an efficiency thing so that work can always be done while the examiners are testifying on their cases.
Would you also describe to the jurors the roles that you have played yourself in processing of this case and the analysis that was done?
Well, again, I supervised the entire process of this case as far as the method development, the receipt of the evidence, the decisions that were made on what was analyzed, when it was analyzed, how it was analyzed, and then took the results and compiled them, formed an opinion, my opinion, as what they meant, wrote the report myself, issued the report after it had been reviewed by an independent scientist that works within my unit, and of course, here today to testify.
And these items of evidence that you have testified to just now in front of the jury, did you personally examine these items?
Yes, I did.
And thus, that's why your initials are on each of those bags.
Yes.
May I proceed?
Actually, I think you are not going to finish before lunch, so I think I'm going to take a break at this time. Members of the jury will take a lunch break at this time. I will remind you not to discuss the case amongst yourselves until we resume, and we'll see you after lunch. You may be seated. Counsel, I would like to see you briefly in chambers before we break for lunch. At this time, we're back on the record. Mr. Gahn, you may resume.
Thank you, Your Honor. Before resuming the testimony, I would like to inform the court that we have marked as exhibits Exhibit 465 and Exhibit 466. 466 is the PowerPoint demonstration that Dr. LEBEAU was using to explain his testimony for the jurors. We have probably gone through about half of it. There will be some more coming. And Exhibit 465 is a CD-ROM of that PowerPoint demonstration. I would move those into evidence at this time.
No objection.
Very well, they are admitted.
Now, Dr. LEBEAU, you just finished testifying about some of the samples that you received for testing at your laboratory, namely these 3 blood swabs that came from the RAV4 and 3 control swabs, correct? That came from the RAV4?
Actually, 6 controlled swabs. There were 2 of each.
2 of each. Thank you, doctor. And did you also receive a blood sample from Stephen Avery in this case?
I did receive a blood sample that was reported to have been taken from Stephen Avery, yes.
I'm going to ask you that be marked as an exhibit at this time. I'm going to have that brought to you for your examination. First, could you state what the exhibit number is? Is that?
This is Exhibit 478.
And do you recognize that?
Yes, I do.
And how do you recognize that, sir?
Again, I recognize it by the initials of the technician who opened this. Some of the markings that we did place on it, unfortunately, our lab number has been covered up by crime scene tape, or evidence tampering tape, rather, from the Wisconsin State Crime Lab in Madison, apparently.
And if you were to open that container, would you be able to make further identifications of the blood vial that you tested in this case?
Yes, I would be.
Would you do that at this time, sir?
Yes.
Before that happens, I recall there was some decision about fingerprint evidence on the vial. Has that matter been resolved?
It's been completed.
Defense is satisfied?
Let's go to sidebar for a minute.
Alright, don't open it any further, please. I should indicate for the record that during the sidebar a question was raised about the evidence tape on the vial, which the parties are free to go into their examination. It was also pointed out to the court that witness, in fact, does have latex gloves on, something unfortunately in this courtroom I can't really see from the bench. But go ahead, you may proceed.
All right, thank you, Your Honor.
I'm going to try to open it. Oh, okay, it's reversed. I'm a little concerned that I'm going to throw a vial of blood when I open this. There we go.
And would you explain to the jurors why a vial of blood is packaged as it is?
Well, this container is a shipping container to ensure that the tube inside doesn't break. It's very high density plastic material and packaged on the inside with cotton and then further packaged on the inside with yet another tube that is heavy duty, like a plastic material, so that the tube If it were to break on the inside, the blood would remain actually in this secondary container here. It's just a safety precaution. Opening and being able now to see the tube, I can recognize our laboratory number as well as the initials of myself and the technician that performed the actual analysis on this blood.
May I see the tube, counsel?
Certainly.
I'll let you hold it.
And does that blood tube that's contained in that container have the name Stephen Avery written on it?
Yes, it does.
Now, you may put that aside for the moment, and I would like you to explain to the jurors what you mean by what are control samples as it pertains to control samples that were taken in this case and sent to you.
Well, a control sample is simply a replicate swab of the area near the stain that was collected to look for any contamination that would count for positive findings you actually find in the item that you're analyzing. So in this case, the blood stain itself, it was a swabbing of the area around it to ensure that there wasn't any contaminants that would interfere with our particular analysis.
And why would they be particularly helpful in this case for your analysis?
Well, for this particular case, because in part, as I indicated, EDTA is widely used in a number of commercial products. So you would be concerned that the inside of the car, for example, may be processed with a cleaning agent that may leave a residual amount of EDTA behind. So you want to make sure that that isn't there in case you have a positive finding in the blood stain, because that could confuse the interpretation of the results.
When you receive a case submitted to you for an analysis, do you routinely take photographs of the items that are sent to you?
Yes, I do, as well as my staff routinely does that.
And that is something that is in the protocol of the FBI in your chemistry unit.
It is within the protocol of the whole FBI laboratory to document, to every extent that we can, document the evidence as it is received into the laboratory and into the unit.
And was this done in this case?
Yes, it was.
I'm going to ask Mr. Fallon to bring you 6 photographs. I would like you to look at those. And if you were to take the top photograph, turn it over and identify the exhibit number, please.
This is exhibit 458.
And how do you recognize that photograph?
Yes, I do.
How do you do that, sir?
I recognize our laboratory number and the item designation we gave to this particular item of evidence.
And how does that photograph, would you explain to the jurors how that corresponds to the evidentiary items that you have in front of you?
Yes, this is a photograph of the blood swab that was reported to have been taken from the ignition area in the RAV4.
And is that photograph now being displayed on the large screen?
Yes, it is.
And could you just explain to the jurors the condition of this swab when you first saw it?
When it looks exactly like you can see in the photograph, that's how we received it.
Objection again. He's got to testify. It's not clear whether he saw it or whether he reviewed it or whether he is talking about his lab staff.
The objection is sustained.
Did you review this photograph? I mean, you have seen this photograph before?
Yes.
And did you yourself look at the swabs that were submitted to you for analysis?
Yes, I did.
And could you describe for the jurors the condition of the swab that you actually saw?
Again, exactly as you see on the screen, this is the condition of the swab when it was received in our laboratory and when we opened it for the first time. This is the photograph of it. It was obvious to us that this swab had been analyzed or at least cut at one point previously, because it wasn't the typical rounded shape you would expect on a cotton-tipped applicator. It appeared as if the portion of it had been removed, and that was consistent with what we had been told had occurred with this particular swab prior to our analysis with it.
Would a laser pointer be helpful to you
Yes, it would.
in pointing out to the jurors?
So specifically this area here, the top portion appeared to have, that the top had been cut off.
And does this photograph in Exhibit 458 accurately depict this swab from the dashboard of Teresa Halbach's car as you observed it?
Yes, it does.
Would you go to the next photograph and identify which exhibit that is?
This is Exhibit 459.
And how does that correspond to the evidentiary items in front of you that you have already testified about?
This is a photograph of a swab that was reported to have been collected from the rear passenger door area from the RAV4.
And did you personally look at the swabs that were submitted in this case from the rear passenger door of the area of the RAV4?
I did, yes.
And does the photograph that you have, is that being displayed now on the large screen?
Yes, it is.
And again, could you point out to the jurors what you observed about this swab?
Again, this swab had what appeared to be blood on it. And again, it was obvious that a portion of it had been cut or removed prior to it arriving to our laboratory.
And does the photograph that you have in Exhibit 459 accurately depict the condition of the swab from the rear passenger door area as you observed it?
Yes.
And would you go to the next exhibit, please, and identify it?
This is Exhibit 460.
And how does that correspond to the evidence samples that you examined in this case?
This is a swab that was reported to us as having been collected from the CD case that was found in the RAV4.
And does that photograph, is that being depicted now on the large screen?
Yes, it is.
And did you personally examine this swab?
Yes, I did.
And please describe for the jurors the conditions that you observed.
Again, this swab appeared to have been sampled previously. There did not appear to be a great deal of blood on this particular swab, suggesting that there was little to begin with in the previous analysis, perhaps took the portion that would have been useful to our particular examination.
I would ask you to take the next exhibit, which would be Exhibit 461, I believe, the next photograph, please, and identify that exhibit number.
Exhibit 461.
Yes.
This is, these are two control swabs reported to us as control swabs.
And can you correspond those swabs with the evidence samples that you received for analysis?
Yes, these were control swabs that were collected from the area near the ignition switch.
And are those swabs that are in the photograph now being shown on the large screen?
Yes, they are.
Could you take the next exhibit, please, and identify it?
Exhibit 462.
And what is that a photograph of?
These are control swabs that were reported to us as having been collected from the area near the staining on the rear passenger door of the RAV4.
And the next exhibit, next photograph, please.
Exhibit 463.
Yes, would you identify that and tell us which evidentiary item that photograph corresponds to?
These are control swabs that were reported to us as having been collected off of the CD case that was found in the RAV4 pickup.
And all these swabs, the controls as well as the bloodstains, did you test these samples for the presence of what you described to the jurors as EDTA?
Yes, I did, or we did.
I'm sorry, which is it? You said I did, we did.
Collectively, we did it within my unit, my staff and I, yes.
Would you explain again to the jurors just how the process works at the FBI laboratory, what your role is, and the role of your technicians, and what is the typical way that a case is processed?
Throughout the FBI laboratory, we have, again, technicians that do a vast majority of the actual hands-on analytical work, saving the staff that is responsible for compiling the results, reviewing the results, ensuring that all of the quality standards are correctly documented in the results, preparing the report, testifying, etc. Assuring that they are available to do their job, we have technicians that do the vast majority of the analytical work.
And again, what were you looking for when you tested these swabs?
We were looking for the presence of EDTA specifically, as well as the iron complex of EDTA. And if I could go back to the presentation I had used earlier.
Would this be helpful to the jurors?
I believe it would be.
Please do.
So specifically, we were looking for the free form of EDTA. This was the EDTA that was in excess and never bound to any metals in the blood sample, as well as the presence of the EDTA that actually bound to iron. And again, we chose iron over calcium because iron tends to be present in about a 10 to 30 times higher amount in the blood sample than you would expect calcium to be there.
When was the last time your laboratory at the FBI tested for the presence of EDTA in bloodstain?
The last time we, within the FBI laboratory, analyzed the bloodstain for EDTA was in the O.J. Simpson trial in the mid-1990s.
Why is that so long ago? Why is that the case that it's been such a long time?
Well, simply because we haven't had any request to do the analysis since then. We, as I indicated earlier, we don't go in search of work to do. The investigators call us and ask us if we can provide analytical assistance. We have never had a request that I could recall since O.J. Simpson trial in which prosecution was interested or an investigation was interested in determining whether or not EDTA was in a bloodstain.
Are there routine cases and non-routine cases that are submitted to the FBI laboratory?
Yes, there are routine and non-routine cases.
Could you explain the differences to the jurors, please?
Well, we do many examinations that we consider routine. And by that I mean these we're doing maybe not weekly, but at least monthly. Examples of this might be something like in a bank robbery, where an individual robbing a bank is given a dye pack. And that dye pack goes off and leaves a stain on the clothing or on the money of that individual. We'll analyze that stain to determine whether or not a very unique dye is present that's associated with dye packs. That's a very routine examination for us. We're one of the few labs in the country that do that analysis, and those types of cases tend to be federal cases. Another routine examination we do is looking at unknown powders that are mailed in threat letters. We have a whole lot of these happening throughout the country. Our laboratory tends to get those unknown powders and tries to identify what those powders actually are and assess whether or not they're a true threat. Again, that's a very routine thing. DNA in our laboratory is a routine thing, especially as you can get it, as well as the latent fingerprints. You can't get much more routine. On the other hand, we do a whole lot of non-routine examinations. These are examinations that the state labs would not typically put together a procedure to do because they may get this request once in their lifetime. So we're often called upon, especially in my unit, we're called upon to develop a technique to analyze for a specific chemical, a unique chemical. And we may not do that again for a decade. It is not uncommon at all. So that would be an example of a non-routine examination. An example of some ones that come to mind recently is looking for insulin in a syringe. Most state labs wouldn't do that. We get that request maybe every 3 years to do something like that. Looking for a new drug that just recently came on the market that cannot be a routine examination. So we would develop that as a non-routine procedure and then perform analysis on the evidence. So it's very common in our unit and it does take up a considerable amount of our time to do.
Are you familiar with the crime that has been referred to as a facilitated sexual assault?
Yes, I am.
Do you have any expertise in this area?
Yes, I do.
Please describe for the jurors your expertise in this area.
Well, I'm considered one of the country's experts on this particular topic. I do a considerable amount of training, not just in the United States, but throughout the world, on drug-facilitated sexual assault and drug-facilitated crimes. I have written a number of specific articles that have been published in peer-reviewed journals. I have also co-authored a book on drug-facilitated sexual assault.
And what is a drug-facilitated sexual assault?
These are crimes that people typically think of as when someone is slipped a drug secretly and that drug knocks them out, incapacitates them so that a perpetrator can potentially assault them, sexually assault them without them resisting the attack.
And what are these drugs that are used to accomplish that?
Objection to relevance at this point.
Well,
Mr. Gahn,
I have a few more questions and then I will wrap this up. I just wanted to show the chemical testing and what was done on this drug.
And why? We test chemicals every day. What's the relevance here?
Well, that's the point of this, to show how the procedures were developed for this non-routine case. It's just a few more questions.
This is a foundational question for something else.
Yes.
Alright, if you can relate it, I will allow it to continue.
Did a time come, these drugs that are used for the drug-facilitated sexual assaults, did a time come when your lab was requested to test for these for the first time?
Yes, of course.
And what did you do? Did you develop a procedure to test for these drugs that are used in drug-facilitated sexual assaults?
Yes, we did.
And why was it important to do that?
Because we didn't have a procedure that had been validated and put online, as we would call it, to do the analysis for these drugs. So there's always a first time for everything, of course, and we had to develop a method and validate it and then use it in cases. And it eventually became a very routine examination that we now conduct, but initially it was the first case where we were asked to do this analysis.
And how often do you get requests to test for chemicals that you have never tested for before?
I would say approximately 20% of our caseload are requests to do unique, non-routine types of examinations.
And in this case here, did you develop a procedure or a protocol to test for the presence of EDTA and bloodstains?
Yes, we did.
And did you specifically develop those procedures for this case?
Yes, we did.
I'm going to ask Mr. Fallon to bring you what has been marked as Exhibit 434 and ask you to identify the document.
This is a copy of the procedure that we developed and used in the evidence for this case.
And was there anything in the scientific literature that helped you develop the procedures that you use in this case?
Yes, there was.
I'm going to ask Mr. Fallon to bring you what has been marked as Exhibits 436 and 437, and I ask that you examine them, please. And what is Exhibit 436?
436 is an article entitled The Analysis of EDTA in Dried Bloodstains by Electrospray, LC-MS, and Ion Chromatography, published in the Journal of Analytical Toxicology in November-December 1997.
And what is Exhibit 437?
Exhibit 437 is an article entitled Determining EDTA in Blood, published in a journal entitled Analytical Chemistry in August 1997.
And what is the Journal of Analytical Toxicology?
This is the Journal of Analytical Toxicology is one of the most relied upon professional journals for individuals in the field of toxicology, but more specifically forensic toxicology.
And what is the Journal of Analytical Chemistry?
Analytical chemistry is one of the most relied upon professional journals for those that practice analytical chemistry.
And are those considered to be scholarly, authoritative publications in the scientific community?
Absolutely.
And do you consider those articles to be peer-reviewed?
Yes, they both are.
And what do you mean by an article or a publication being peer-reviewed?
Peer review, what that simply means is a scientist that does research and then wants to publish that research. What they will do is write up a manuscript and submit it to the editor of that particular journal. Now, in some science, what we do, we don't just publish because somebody sends us an article, but that the editor has the responsibility of reviewing that article and finding experts in that area of study to review the work that was done in that particular manuscript. So the editor sends that to reviewers. It's done blindly, so no one knows who the reviewers are except the editor. And the reviewers then make comments. They critique the manuscript, make suggestions for improvements in the science, and then send those comments back to the editor, who then passes those comments onto the original author of the manuscript. Then the author of that manuscript must meet the recommendations and the suggestions of the peer reviewers and send it back to the editor, who then makes a decision as to whether or not it's suitable to be published. So it's a check and balance to ensure that what is published is actually scientifically valid information.
And did you develop your protocol, which you have identified as Exhibit 434, that you developed for this case to test for EDTA and bloodstains based upon procedures in those two exhibits?
Yes. One of the things that we do when we're looking for a method to develop, when we're deciding we need to develop a method that we don't currently have a written standard operating procedure for, we go to the literature, published literature, and we try to find a method that's been used and published by another group of scientists. And we basically find one that meets our needs, that we can apply with the instrumentation that we have in our laboratory, and that will meet the needs for the particular analysis that we're being asked to perform. And the first article I refer to, Exhibit 436, from the Journal of Analytical Toxicology, this article met those needs. We essentially base our entire method of what was published in this article with the article Exhibit 437 from Analytical Chemistry, supporting the ideas that were presented in the article from the Journal of Analytical Toxicology.
And did you make the improvements to the procedures that you observed in the publications from the analytical chemistry and analytical toxicology?
I believe we did make some improvements when we put the method together and actually validated it.
What were those improvements?
Well, one thing we did, we used a different type of LC-MS for analysis. It was a newer technology than it was used in the 1997 publication. Additionally, we introduced what's called an internal standard into our method. And simply what this is, it's a control that we introduce into every sample as we're doing the analysis. It's a control that tells us whether or not the analysis, not for the whole batch of samples that we're running one at a time, but for each individual sample to show us that it actually worked as it was supposed to work. Additionally, we added one more experiment that than what they were suggesting to do in this paper that looked for the free-form EDTA in not just one technique, but two techniques.
What was your thought process in approaching this case that was sent to you?
If I can go on to the presentation.
Will this be helpful to the jurors?
It certainly will be.
Then please do.
The thought process is simply there's going to be one or two scenarios when you're dealing with the notion that blood was planted from an EDTA tube. First scenario is that blood stain that is found at the crime scene is either there from someone bleeding, actively bleeding, such as indicated here. If that blood then dries and a crime scene technician comes along and swabs that particular blood stain, they are going to put some of the blood onto that swab. And then if that swab is sent into the laboratory for doing an analysis, the laboratory will look at the swab and analyze it. That's scenario one. Second scenario is if the blood is actually planted from an EDTA tube, again, a swab from a crime scene technician that comes along and samples that stain, again, that swab being sent to the crime lab to analyze the stain. So essentially, if you look at that swab that's sent to the laboratory, you have one of two potential options there. The first option is if you find the presence of EDTA and the iron complex of EDTA on that blood stain on the swab, and you don't find any significant EDTA on your controlled swab in that area. Remember I said you need to make sure that a cleaning product wasn't used that would confuse the interpretation of the results. If that's the case, you find EDTA present on that swab, then that's an indication that that blood was indeed planted or came from a tube, such as purple top tube. The other scenario is that you do not find EDTA or that metal complex of EDTA, and that would then suggest that the blood came from active bleeding and not from an EDTA preserved tube.
And the blood tube that you have identified as being the blood tube with the name Stephen Avery, is that the purple top tube?
Yes, it is.
And in this case, did you follow the protocol that you developed to test for these two scenarios?
Yes, we did.
First, would you please describe to the jury the steps that you took to validate the procedures that you used in this case?
Well, once we had ensured that all of our instrument settings were correct, based again on the paper from the Journal of Analytical Toxicology, we performed the required validation steps that are required of our unit based upon the requirements of our laboratory, which again are based on the requirements of our accrediting body. And we performed an analysis initially to determine what our detection limit was for this particular analysis. Basically, how low could we go to find EDTA? And we did that one of two ways. We did it first by taking solutions of known concentration of EDTA and continuously diluting them, analyzing it, diluting it, analyzing it, diluting it, until we got to the point that we could no longer meet the requirements that we had written into the protocol as far as something being a positive or a negative. When we reached that lowest concentration, that's what's called our detection limit. Another test we did, though, is we took a tube of blood that had been preserved with EDTA, and we put different size drops of blood on a microscope glass slide, and we let that dry, and then came along with a swab, swabbed it off, and did again the analysis like we wrote in this procedure on those swabs until the point that we could no longer detect the presence of the EDTA. And as it turned out, with that particular analysis with the spot, the lowest volume we can accurately measure is 1 microliter of blood. And 1 microliter of blood is the equivalent of about 1/50th of a drop. So that's as low as we could accurately measure a volume out onto the microscope slide. And we were still able to find the presence of EDTA and EDTA with the iron complex on that 1 microliter drop. So that, combined with the fact that our decrease in concentration suggested that we could go as low as 13 parts per million with analysis, 13 parts per million, we knew where we were as far as sensitivity with this particular method. The second thing that we did was to look for the presence of interferences that would cause us some confusion when we did the analysis. Since we were dealing with blood, we looked at the number of blood specimens that were not preserved with EDTA. They had other preservatives in them and blood that had no preservatives. And we ran this through the same test. We put some of that blood onto swabs, let it dry, and then ran through the procedure. That again was to demonstrate that blood doesn't interfere with the test. None of the components that are normally found in blood interferes with the test. The third thing we did was something that's called matrix suppression, an evaluation of suppression. You're putting proteins and all these other things into the instrument when you're dealing with blood. So what we wanted to also verify is that these other things, not just that they didn't interfere and cause signals that we shouldn't, that would interfere with our ability to detect or identify EDTA, but also that the signal itself didn't drop because we were dealing with blood. Now, this is very important when you are doing a method with LCMS, particularly with the technique as this paper describes, electrospray LCMS, because it's very well known that electrospray LCMS, this is one of the criticisms of the particular analysis, is that with some analytes, other things that are in the sample can cause the signal in, if it were this high, for example, in water, when you run it in a particular matrix, say like blood, or if you were doing food, that those things, other chemicals could cause that signal to drop. So we had to evaluate that so we knew if this was a significant drop in the signal. And what we found is that at a very low concentration, we had an average drop in signal of about 3%. And at the very high concentration, we had a drop in signal of about a third. And again, that's not very significant. The next thing we did was to analyze for carryover. And this is an important concept anytime we're doing chemistry, analytical chemistry, is that when you shoot a sample that has a chemical in it, you want to make sure that that sample doesn't stick around. Residual amounts of that sample don't stick around and show up in the next sample that's injected. And this is a particular concern because this paper, again, from the Journal of Analytical Toxicology, talked about this being a problem with EDTA. And their recommendation in this paper to avoid carryover to the next sample or the sample that follows was to extract blank blood, unpreserved blood, and shoot that as a negative in between samples that were associated with the case. So we evaluated carryover as part of our validation, and we actually found with the system that we were using today that we had essentially no carryover. We did not find any. So I attribute that in part because technology has changed and the tubing, etc., within the instrument is no longer made of metal like it was in 1997. We're using a high-density plastic material, and that's probably why that occurred. But those are the steps of the validation that we undertook for this particular analysis.
And after completing this validation, did you use the LC-MS technology with the procedures that you developed to test for the presence of EDTA in the samples that were sent to you in this case?
Yes, we did.
And after all these different types of analysis that you performed, were you able to reach a conclusion concerning the presence of EDTA in the control swabs from Teresa Halbach's RAV4?
I was.
And what was that conclusion?
We were not able to identify any presence whatsoever of EDTA or the EDTA iron complex on the control swabs, any of the control swabs from the RAV4.
After all these different types of analysis that were performed, were you able to reach a conclusion concerning the presence of EDTA on the blood swabs that you tested from Teresa Halbach's RAV4 that were sent to you in this case?
Yes, sir. Yes, I was.
And what was that conclusion?
Again, we were not able to identify any indication of the presence of EDTA or EDTA bound to iron in any of the swabs that were submitted to our laboratory that contained blood and were reported to us as being collected from the RAV4.
And after all these different types of analysis that you performed, were you able to reach a conclusion concerning the presence of EDTA in the purple top tube that came from Stephen Avery?
Yes, I was.
And what is that conclusion?
That the tube of blood, the purple stopper tube of blood that was reported to have come from Stephen Avery, did indeed contain significant amounts of EDTA in it.
Dr. LEBEAU, based upon your training and experience, and based upon your test results using the LC-MS technique, and based upon all of the data that you reviewed and all the compilations that were done in this case, do you have an opinion to a reasonable degree of scientific certainty whether the blood stains from Teresa Halbach's RAV4 that you tested came from the vial of blood of Stephen Avery that was in the Manitowoc County Clerk of Court's office?
Yes, I do.
And what is that opinion?
It is my opinion that the blood stains that were collected from the RAV4 could not have come from the EDTA tube that was provided to us in this case.
And therefore, which scenario did your testing answer in this case?
Of the scenarios of the board, I think our results rule out one of those two possibilities. It would be my opinion that it could not have been from an EDTA tube.
And therefore, no planting of evidence.
Objection, way over broad.
Without any limitation, yes, sustained. I will sustain the objection, I think. I'm sustaining the objection.
In accordance with the two scenarios that you set out in your thought process in analyzing this case, did the planting scenario prove true?
No, it did not.
Thank you. That's all I have.
A break.
Yeah, members of the jury, would you like to take a full break or a stretch break at this time? Stretch is enough? Okay, we'll take a stretch break at this time. You may be seated.
Before I officially pass the witness, I guess I'd like to just introduce the exhibits of the report of Dr. LEBEAU from the crime lab, which has been marked as Exhibit 435. If you would, just identify that.
Yes, Exhibit 435 is the laboratory report I prepared for this case.
And does that contain your findings and conclusions in this case?
It does, yes.
Thank you.
Is the state moving for admission of any exhibits at this time?
Yes, I would move for the admission of Exhibit 475 to 478, 434 through 437 and 433.
No objection.
Very well, those exhibits are admitted. And Mr. Bruton, you may begin.
This PowerPoint isn't an exhibit, is it?
It is.
Which number?
I will object to that, but the others I won't.
What number is that?
466.
465.
465 is the CD-ROM.
All right. Do you wish to be heard later, outside the presence of a jury?
Later.
The other uncontested exhibits are admitted at this time.
Good afternoon, Doctor.
Good afternoon.
I'm sure you're anxious to get back to Quantico, Virginia, where it's not quite so cold.
It would be nice. Yes.
You have your curriculum vitae up there with you?
Yes, I do.
And we had a little bit of talk about your expertise in drug-facilitated rape cases, right?
That's correct.
Also sometimes called GHB drugs, one of those types of drugs.
One of the 60 different drugs used, yes.
Okay. That's the one that maybe most people have heard of. It's the one I've heard of. Okay.
Okay.
When you're going through your CV, you talked about how you authored or co-authored 15 to 20 articles.
That's correct.
How many of those articles did not involve drug-facilitated rape?
17.
Okay. And how many of those involve postmortem fluids, analysis of postmortem fluids? Do you know what I'm talking about from deceased bodies?
Yes, I know what you're talking about. I'm sorry, did I refer to postmortem or did not?
Good.
Okay, I don't know that I can answer that because if I can elaborate.
Well, go ahead.
Well, urine can be fluid from an autopsy, postmortem fluid, or urine can be from a living person. So, an article I published about urine, it would be hard to say if that's meant to be for postmortem or living people. The same with blood. Now, obviously, a liver sample or a brain sample must be from a deceased individual.
Okay. Would you agree or disagree that the majority of your presentations and the majority of your publications involve either drug-facilitated sexual assaults or the analysis of postmortem fluids?
I would disagree.
Okay. You do have some experience in analysis of postmortem fluids, right?
I certainly do.
You certainly do, yes. And in fact, one of your more recent articles you published holds yourself out as an expert in the area of postmortem fluid analysis, does it not?
I'm not sure I know.
Are you?
I know what article you're referring to.
Okay. Are you an expert? Do you consider yourself an expert in the analysis of postmortem fluids?
I do, yes.
Okay, well, we'll return to that in just a moment. You also give quite a few presentations. Just this year alone, looks like out of 9, just one moment, please. Out of 9 times that you've gone around presenting talks this year, 6 of those involved drug-facilitated sexual assaults, right? In 2006, I'm sorry.
Yes, 6 of the presentations that I gave in 2006 were on the topic of drug-facilitated crimes and drug-facilitated sexual assaults.
Okay, so would you agree with me that that's one of your real specialties?
Yes.
And that's what you're often sought after for by conferences.
It's an area that I'm asked to speak on quite frequently, yes.
Have you ever in your life been asked to give a presentation on EDTA interpretation in bloodstains?
No, I have not.
Are you not sought after presenter on that particular topic? Are you?
No, sir, I'm not.
Have you ever before testified in a court of law as an expert who is giving opinions about the interpretation of EDTA and bloodstains?
No.
This jury is privileged to be the first to hear your wisdom on this topic. Isn't that right?
Objection, Your Honor, to the form of the question.
I will sustain the objection.
This jury is privileged to be the first to hear any opinions you have ever expressed in court on the analysis of EDTA in bloodstains, correct?
I wouldn't say they're privileged, but I would say that this is certainly the first time I'm testifying about EDTA in bloodstain. That's correct.
And the reason is this is the first case you have ever been asked to test for EDTA in bloodstains, isn't it?
That is correct.
But some of your colleagues at the FBI laboratory did have the pleasure of testifying on that topic once before, didn't they?
Yes, they did.
In the O.J. Simpson case you mentioned, correct?
Yes.
And I believe you said that, in fact, that's 10 years now, 10 years ago, right?
Yes, at least 10 years ago, yes.
At least 10 years ago. Okay. So in the last 10 years, nobody has come to your lab and asked for your lab to give us the benefit of your knowledge and your ability to test for EDTA in bloodstains. Isn't that right?
It hasn't happened to me personally, not to my knowledge.
Okay. And might that be because your lab screwed up in the O.J. Simpson case?
No, we did not screw up, as you say, in the O.J. Simpson case.
Well, in the O.J. Simpson case, correct me if I'm wrong, tests that your lab did found EDTA in a sock, right?
That is correct, yes.
And the defense used your test to help acquit Mr. Simpson, didn't they?
Could you repeat that?
The defense used your test results in the O.J. Simpson case, your lab test results, to help acquit Mr. O.J. Simpson of that crime, didn't they?
That I don't know. I have no idea. I wasn't the one that performed any of the analysis of EDTA as I testified to
Sir,
in the O.J. Simpson case. I don't know how. I don't know that the defense used that result for prosecution. I don't recall that.
were you working the FBI lab during the O.J. Simpson case?
Yes, I was. I had been there approximately a year.
And you would have us believe that you weren't following what was going on with your lab's testimony in the O.J. Simpson case?
Actually, while that examiner was testifying, I was out on my own testimony robbery trial in Los Angeles myself.
Ah, so you.
I couldn't.
So.
I'm sorry, so I couldn't really monitor the actual testimony in that case.
Sure. You couldn't watch it while it was going on. Is that what you're saying?
That's correct.
And you're telling us that you didn't follow up afterward? You didn't hear all of the discussion in the news about your lab's involvement in that case?
I heard what the media reported, yes, and I heard what our own chemist reported.
Sure. You talked about it in the lab, didn't you?
Yes.
You sat around the water cooler or the lunch table and you talked about it, right?
Yes, we did.
And more than that, shortly after the O.J. Simpson case, your unit, the chemistry unit of the FBI, was accused of misconduct or malfeasance of some sort that resulted in an audit by the Inspector General of the United States of America. Isn't that right?
No, that's not correct.
Objection, Your Honor, as to the relevancy.
Over?
Its foundation.
Overruled.
Your answer was no?
No, that's incorrect.
Okay. Have you read an Inspector General's report from 1999 that involved an audit of your unit?
I have read a portion of the Inspector General's report that was a report on their audit of the FBI laboratory.
Okay. And part of that review involved your unit, the chemistry unit, did it not?
Not to my recollection, it involved the investigation of one chemist within the unit, same individual who worked on the on the O.J. Simpson case. He was specifically targeted with that investigation. It wasn't our entire unit.
Okay.
There were units within the FBI
Sure.
laboratory through that chemical analysis that were looked at the whole unit, but it was not the chemistry unit to my recollection.
Do you know Roger Martz?
I do, yes.
Was he one of your colleagues at the FBI lab in 1997?
Yes, he was.
Did he testify in the O.J. Simpson case?
Yes, he did.
Is he working in your unit anymore?
No, he's retired from the FBI.
Took early retirement, huh?
That would be personnel information that I wouldn't be privy to.
Oh, of course. Well, Mr. Martz, if you read that portion of this Inspector General's report, was the target of complaints about the performance of, or his performance on EDTA testing in the O.J. Simpson case, was he not?
I believe that Mr. Martz was, there were a number of allegations made by the individual who made allegations against Mr. Martz. And there were approximately 10 individuals within the whole FBI laboratory that this Dr. Fred Whitehurst made allegations against. Those individuals were looked at because these allegations, the Inspector General came in and looked into every allegation that was made by Mr. Or Dr. Whitehurst.
Sir, I'm going to stop you here for a second.
Yes, sir.
Are you telling us now that you read the entire report?
No, no, sir.
Okay.
But I do know the history.
All right. Well, we'll get into it question by answer, question and answer, okay?
Yes.
All right. Mr. Marks is one of the esteemed authors of this Exhibit 436, isn't he?
Yes, he is.
In this esteemed publication of the Journal of Analytic Toxicology, right?
It's the Journal of Analytical Toxicology, and he is one of the authors.
Forgive me. He is one of the authors, one of the 4 authors of this article upon which you primarily based your protocol for EDTA testing in this case, right?
That's exactly right. Yes, sir.
The other 3 authors are all FBI employees, right?
Yes, they are.
And in fact, this entire article is based on the protocol that was developed for the O.J. Simpson case by the FBI lab, right?
I believe part of it is, but I don't know that the entire article is based on what was done in the O.J. Simpson case.
Well, the article was written after the O.J. Simpson case was done, right?
Approximately 2 years afterwards.
And the article, in fact, is in an effort to explain to the rest of the scientific world how you guys screwed up when you tested O.J. Simpson's.
Objection, Your Honor, to the form of the question and the relevancy of this.
It's cross-examination. I will allow the question, and I will allow the witness to explain the answer.
Could I get the question again, please?
This article was written by these 4 agents from the FBI to explain to the rest of the scientific world how you guys, your lab, I should say, managed to screw up in the O.J. Simpson case.
Well, that's incorrect on a number of levels, sir. First of all, those are not agents at the FBI laboratory. The only one that was Roger Martz. The others were PhD scientists, chemists, or PhD biologists. That article was not written as any form of excuse or explanation for what our laboratory for in the O.J. Simpson case. That was simply a group of researchers who had the lead, published group lead authors, Dr. Mark Miller as well as Dr. Bruce McCord. They were not in our case working area at the laboratory. They never worked on cases. They're in our research unit. They're the lead authors. They are the ones that did the research. They are the ones that published it. It is quite common for those researchers to give credit to individuals in the case working units who had the original idea.
Okay, so
that is why I'm sure Mr. Martz's name is on that article. He had nothing to do with the actual work done.
Oh, really?
Publication.
So these authors, you're telling us that they put Mr. Martz's name on here when he didn't do anything at all to do with this study or this article?
I believe that to be true.
How about Mr. Bruce McDowell?
Dr. Bruce McDowell, he's an expert statistician and at the time was, as I recall, the ranking manager within the research unit. Again, it's a respect thing where you include your supervisor in the list of authors.
Okay, let's talk for a minute about how the protocol was developed for the O.J. Simpson case, all right?
Yeah.
Just as in this case, a request was made or efforts were started to create a new type of test mid-trial, right?
Well, again, sir, I didn't do the testing in the O.J. Simpson trial. I don't have all the intimate details as to what conversations occurred when the request came in. I was a newly qualified examiner in the FBI laboratory. I had been there approximately a year, so I don't have knowledge about the intimate details that you're asking there.
Well, I didn't realize I was asking intimate details, but let's rephrase it so I'm not, clearly. Was the protocol used in the O.J. Simpson case in existence in the FBI lab before that trial began?
Not to my knowledge, it was not.
It was developed in a hurry while the trial was going or ongoing, right?
I don't know when they started to develop
How long did it take to develop
the protocol.
How long did it take to develop the protocol in the O.J. Simpson case?
I don't know.
Okay, well, Exhibit 437, Determining EDTA in Blood, another scholarly article you refer to, right?
Yes, it is.
Respected in the field?
Yes, it is.
By two authors at the time associated with Cornell University, right?
That's correct.
And they talked about, and part of this article talks about, the FBI lab experience in developing the protocol for testing EDTA in bloodstains that was used in the O.J. Simpson case, right?
I would have to review the article again to answer that question.
Are you serious? You don't know what this says? You don't know if it refers to the O.J. Simpson case?
Yes, I am serious, and I asked to review the portion that you're referring to.
Go right ahead. It's on the first page, Doctor.
What was your question again?
Does that refresh your recollection?
Yes.
And do these authors say, quote, what was wrong with the laboratory testing? First, it was not clear whether the method had ever been used before. Most likely, the method was developed quickly under a great deal of pressure. In retrospect, FBI chemists now believe that the EDTA detected may have been injection carryover in the LC-MS instrumentation. Do you recall reading that?
I do. I can't verify that that's it. You said, quote, I can't verify that, but it sounds like the context is very much that I recall reading in that paragraph.
Okay, so these authors pointed out that the FBI effort to develop a protocol for testing EDTA in bloodstains for the O.J. Simpson case was hurried.
No, sir. They said it appeared to have been hurried. Those authors were not present in our laboratory when that method was developed. I know that to be a fact.
Okay, so you would like to criticize these authors?
No.
This publication now?
No, sir. The portion of that article that was relied upon was the scientific portion, not the narrative.
Well,
it's the science within the latter portion of the article refers to the use of the instrumental technique called capillary electrophoresis, mass spectrometry. Again, it's a technique that analyzed for EDTA.
May I ask a question? This is a cross-examination, Judge.
I thought I was responding.
No, you're not.
Well, the answer goes a little bit beyond what the question was, so...
Mr.
Butin?
Okay, so Exhibit 437 that you considered, that you offered here on direct as one of the two publications that you considered while developing this protocol, you say that you considered the portion of of science in that latter part of it, but you ignored the portion of the narrative at the beginning that criticized the hurried nature of the development of the protocol. Is that right?
Yes, that's correct. It was irrelevant in my opinion.
And you know why? Well, let me ask it this way. It was irrelevant to you because in this case, you were under a time crunch, weren't you?
Yes, I was.
Let's talk about that. Oh, and by the way, just to make it absolutely clear, these two publications that you referred to, Exhibit 436 and 437, were both published in 1997, right?
Yes, they were.
And both of them discuss the use of EDTA test in the O.J. Simpson case, right?
Yes, they do.
And they don't discuss the use of an EDTA test in any other case, right?
No, they don't.
Because, as a matter of fact, no one has ever presented to any jury anywhere, not just you, no one has ever presented a test for EDTA bloodstains in a criminal trial before, other than the O.J. Simpson case.
I don't know that that's true.
Can you tell me another case in this country where an expert has gotten up in court and expressed an opinion that they are able to determine the presence or lack of EDTA in a bloodstain in a criminal jury trial?
No, I can't. But I don't know that it's true that it hasn't happened. I haven't done a search of the legal system to make that determination.
Oh, really?
Really?
So when you were asked to develop a protocol in this case, are you telling us then that you didn't search the public domain to see if maybe someone else had already invented the wheel?
I searched the scientific literature, as I indicated earlier, to see if there were published methods in peer-reviewed journals that are scientifically sound in order to base my method upon. I didn't search the so-called public domain for such a method.
Okay. But in any event, you found no other reference in any other scientific journal across whatever disciplines there may be. You found no other references to any other case or instance where a jury had been presented an expert opinion by somebody who says that they can determine whether or not EDTA exists in a blood stain, correct?
Again, I did not search like legal proceedings.
Perhaps my question was too long. Let's break it down. You searched the entire scientific domain of research articles, right?
Yes, I did.
And in that entire search, I'm talking not just chemistry, but any kind of forensic science journals, right? You looked at those?
Yes, I did.
Okay. And any kind of physics journals or whatever?
I didn't look at physics journals.
Whatever scientific domain you looked at, you found no other case where anyone had done what you're doing here today and come into court and presented an opinion about whether you can determine EDTA in a bloodstain other than the O.J. Simpson case, correct?
That's correct.
All right. Now, you were first contacted by someone on the prosecution team in this case in late December of 2006, correct?
That's correct.
Let me go back. I'm sorry, I need to clear up one thing in this exhibit 437 to 436, the FBI. I'll bring it back to you because we talked about carryover, right?
Yes, we did.
And the authors of that particular study apparently believed that carryover explained why they found any kind of EDTA in Mr. O.J. Simpson's sock, right?
Again, I don't recall that specific detail being in the paper. I think, yes, they talked about carryover as being a problem in the O.J. Simpson case. I don't know if that was with a sock or if it was the blood stain itself or a swab.
Okay.
Or what the evidentiary
That's fair.
material was.
That's fair. I don't expect you to remember the particular evidentiary item, but you understand, though, that the conclusion was that carryover was the result of the EDTA reading. EDTA positive came from carryover, right?
There was a small signal for EDTA, as I recall, that was attributed to a previous injection of EDTA. Again, carrying over into a future injection.
All right. So then, if carryover explained that small signal of EDTA in whatever piece of evidence that was in Mr. Simpson's case, then in fact, there may not have been any EDTA in that piece of evidence, right?
That's correct, yes.
And then if there was not EDTA in that piece of evidence, when the FBI concluded that there was, then the FBI lab was wrong in that case, right?
I don't know that the FBI laboratory concluded that there was EDTA in that case. Again, I never read the report that was issued in the O.J. Simpson case. I didn't do the work myself. I don't know what the actual report was, and I don't know that they claimed there was a significant amount of EDTA.
All right. Well, let me ask it this way. Either the protocol that was used in that case was faulty, or the work performed was faulty, in order for there to be this report of a finding of EDTA on the evidence sample, right?
No, I disagree.
Well, which is it?
Well, if I can elaborate.
If you would like to, go right ahead.
Okay. What I believe is that the method was not well validated, quite frankly.
All right.
That's my understanding.
Okay, I'll accept that.
Mr. Bruton, I think I'm going to stop you there.
Okay, I see it's about 2:30.
It's 2:30, so members of the jury will take a break at this time. I will remind you again, as usual, do not discuss the case during your break. You may be seated. Counsel, I will ask you to report back at 2:45.
Okay.
Mr. Butin, you may resume.
Thank you, Your Honor. Okay, now, sir, you were first contacted by somebody from the prosecution team in late December of 2006, right?
If I could correct some testimony I made earlier, I realized I made an error, and then I can answer your question. Is that all right?
Well, we can wait for redirect, but what is it on one of the articles that you were referring to?
It was in response to one of your questions.
And what was it?
You asked me earlier, as I recall, if both these articles refer to the testing in the O.J. Simpson case. And during the break, I reviewed the articles from the Journal of Analytical Toxicology and realized that I had mistakenly agreed with your statement. This article does not refer to the O.J. Simpson case, so I wanted to set the record straight.
Oh, okay. Well, let's just for a couple minutes follow up on that. This article is written, though, by 4 FBI employees, right?
Yes, it is.
Including Mr. Martz, right?
Yes, I'm not changing my testimony on that, sir.
Okay. Who testified in the O.J. Simpson case, right?
Mr. Martz.
And the article discusses the test on a sock. Is that right?
You will have to show me that, sir. I couldn't find it in that article.
Let me see if I can find it in mine. I'm going to have Mr. Strang take a moment and look at it, and then we can move on and not bore the jury, okay?
Yes, sir.
Oh, all right. He's quicker than I am. If you would take a minute and look at page 526, begin with the circling of the word, but that will help refresh your recollection.
Okay. The word a sock is circled, but there is no reference to the O.J. Simpson case. And as I said, I agreed with your statement that it referred to evidence in the O.J. Simpson case, and I need to withdraw that agreement to set the record straight.
Well, do you know of any other case in the mid-90s when the FBI testified about EDTA on some sock? Yes or no? Do you know of any other?
No.
No, right.
No.
Okay. And maybe just so the jury is a little bit can understand your concerns about your testimony being accurate, there's something called a court testimony monitoring practice that the FBI is engaged in, right?
That's correct.
And the FBI, at least for the last number of years, has a practice of following up what their agents or lab people testify when they come into court, right?
That's correct.
And what you say here today to this jury could be followed up and reviewed by your supervisor.
That's right. Our testimonies are reviewed as part of our accrediting body's requirement.
And so you want to be absolutely sure that you don't say something that may be construed negative about the Bureau by your supervisors unless it's true, right?
Sir, I just want to make sure I'm telling the truth if I'm under oath.
All right. If I can return, my question was that you were first contacted by somebody in the prosecution team in very late December of 2006, right?
Yes, sir.
Approximately 2 months ago, correct?
Approximately 2.5 months ago.
All right. And that was the first you had ever heard about this case, or was it?
Yes, it was the first I heard of this case.
And as you thought about, well, geez, what can I do here to do this test? You thought maybe an LC-MS instrument might be an appropriate instrument to try and run a test for this particular chemical. Is that fair?
Not in December of 2006.
All right. Let me move forward just to make it a little broader then. Are you later committed to do a protocol or test? In this case, you thought about that particular instrument, right?
Yes.
And that instrument, as you said, has been used for decades, right?
Yes.
It has commercial applications.
Yes, it does.
So, for instance, the petroleum industry may use it to determine the, chemical compositions of products that they are putting out.
Perhaps.
Pharmaceuticals, I think you mentioned. One of the things that they have to do is make sure that according to the FDA regulations, that the drugs that they are making contain the chemical makeup that they represent, right?
The pharmaceutical industry does use LCMS and LCMS-MS techniques.
Sure. And they use it for all kinds of reasons, including testing how long their drugs may last, right?
Generally, no. They tend to use the LCMS and LCMS-MS for metabolite studies and looking for what the body converts these drugs into to monitor.
I see. Okay.
Studies that are done.
So they're looking, they use the instrument to see if how the drug breaks down into some other metabolite, you say, right?
That's exactly right.
And they want to be sure that there's not side effects, that this drug breaks down into something that might be toxic, for instance, right?
That might be one thing that they're looking for, yes.
And they're looking to see that the drugs don't break down too quickly, or they're just trying to find out how quickly the drug will break down, for one thing, right?
That's part of it, yes.
Expiration dates. That's what the whole point of having those kinds of things on drug labels and whatnot, right?
Well, I don't know that they're studying it for expiration dates. Again, they're studying it for metabolites, what the body is converting it into. Shelf life, which I believe you were referring to here, is a completely separate issue.
Okay, but that's an issue as well. What they want to make sure that their drugs are, working long enough to be effective. In other words, someone doesn't take a drug out of their medicine cabinet 5 years later and it's no longer, it's way past the expiration date or something.
And for some drugs, they may need to do that to verify that it's stable.
Okay, so you settled on this particular instrument, but before you got there, the person you spoke to was Mr. Gahn, correct?
That is correct, yes.
And what you told him in December when he asked if you could run a test to see if there was EDTA in a blood stain was that it would take you 3 to 4 months before you would be able to get him any results, right?
Yes, that's what I told him.
Okay. And that was in part because you knew that it had been so long since the O.J. Simpson case, the last time your lab had done this kind of a test, that you would need to develop or retest some protocol, right?
That we would need to validate the protocol in order to use it.
Sure. And that you would have to, in order to do that, go through a number of tests and whatnot in order to satisfy the validation process that you thought was necessary, right?
That's exactly right, yes.
And so you told them about 3 to 4 months.
That's the standard estimate I give. When we're asked if we can develop a new method, my standard response is 3 to 4 months, and that's what I recall responding to Mr. Gahn's request.
Okay. So when you say you get these non-routine cases and you're asked to develop these protocols, typically it takes 3 to 4 months.
It depends, quite honestly.
But that's the standard answer you give.
It's the standard answer.
Okay. And he told you, well, that wasn't going to work with the trial date that was set in this case, right?
He relayed to me that there was an upcoming trial date and indicated that they may need the results faster in order for it to be used in this case.
Okay. And yet, in that discussion with Mr. Gahn, you still could not promise to do anything quicker than 3 to 4 months, right?
In my recollection at the time was I actually suggested that they try to find another laboratory to do analysis. That was my initial response because we had the holidays coming up. This was right before Christmas. And most of my staff is gone for, at the end of the year, we lose our leave if we don't take off and use it. So, realistically, looking at the scenario we were presented with, I thought 3 to 4 months was probably a fair estimate. And the other thing we always have to keep in mind that we're primarily federal law enforcement investigative body. So if a bomb goes off, if there's a terrorist attack,
Sir,
there's...
excuse me. We would like to get you back to Quantico, Virginia sometime soon. So the question didn't require that long of an answer. If you would just try and focus on the questions and give us some answers.
I was trying to, sir. I'm sorry.
Okay. And if you need to, you will have an opportunity with Mr. Gahn. You can elaborate your answers and explain them further. And if I cut you off and it's unfair, just tell me, okay?
Yes, sir, I will.
All right. Thank you. So you gave Mr. Gahn the standard response. Then in January, you were contacted again by someone else about this case to see if you could do something a little quicker, right?
I was, yes.
And that was the FBI office, or who was that? U.S. Attorney's office or what?
It was our local FBI office,
In Milwaukee?
Green Bay.
Green Bay. Okay. And after speaking with them and learning something about the case and the trial date that was starting February 5th, you said, oh, well, I think we can do it faster than that, right?
No, sir.
You didn't?
No.
Did you say you would try to do it faster? Is that the difference?
I told the agent that called me from our field office in Green Bay. I explained to him that I had had numerous conversations with Mr. Gahn, and I had agreed that we would accept the evidence and analyze it for this case after we had developed a method and validated that method.
Okay. But you told Mr. Gahn, or you told this FBI agent in Green Bay, that you thought you would be able to do all of that while the trial was going on, and you would be able to get results by the end of the trial, right?
No, sir. I told him that we would do our best to get the work completed in the time requirements that were needed.
Okay. And you knew that those time requirements were that it's what, early March now. You knew that you were going to have to get something in probably by around the end of February, right?
I believe the deadline were given to us essentially this week to have the actual results in.
Okay. Actually, March 9th, I think, right?
That sounds familiar, yes.
Okay. So you beat the deadline, right?
We did, yes.
Because your actual report is dated February 26th.
That's correct.
Now, you testified about why the FBI would have any interest in this case in the first place. Do you recall that with Mr. Gahn?
Yes, I do.
You said that, oh, the FBI has a concern about public corruption, correct?
It's one of the types of investigations that we have a classification for within the FBI, yes.
Sure. You have agents that go around and do investigations when there's an allegation of public corruption, right?
That's correct, yes.
It's not just your chemistry unit that gets involved, right?
Of course not, of course not.
You tell me. Now, you knew this case, by the way, was charged against Mr. Avery in November of 2005, 16 months ago, approximately, okay? Are you aware of that?
That the charges were made then?
Yes.
I don't know when the charges were made, sir.
Well, you looked at these swabs that you were testing, right? And they had some dates on them.
Yes.
Some of those dates were November of 2005, right?
That's correct.
So you knew Mr. Avery must have been charged by that time.
No, sir. I just knew that's when the date was indicated the specimens were collected. I don't have any knowledge of when the charges were made.
Okay. In any event, can you tell me what investigation was started by the FBI to investigate allegations that Mr. Avery made upon his arrest publicly that the police had planted his blood in Teresa Halbach's car?
I have no knowledge of any investigation.
In fact, there was none, was there?
I have no
Okay.
knowledge of it, whether there was or was not.
Can you tell me when the U.S. attorney convened a grand jury investigation to investigate allegations of public corruption made by Mr. Avery against police officers in this case?
I have no knowledge of whether or not they did it.
Okay. And can you tell me when any agents from the FBI spoke to Lieutenant Lang, Lieutenant Colborn, or any other person involved in the investigation of this case?
Sir, I'm a scientist. I'm not a law enforcement officer. I have no knowledge of anything of that nature.
Now, you were trying to find out in your test simply whether or not there was a corrupt, dishonest criminal cop who planted evidence to frame Mr. Avery in one scenario, right?
I'm going to object, Your Honor. I don't believe that was his testimony.
I can rephrase it. It's a little cumbersome.
Go ahead.
You testified one of the FBI's concerns was that if there was a corrupt cop on the street and doing something illegal, and certainly planting evidence to frame somebody would be illegal, right? Would you agree with me?
Yes, I would.
Okay. And that one of the functions of the FBI was to ferret out bad cops like that, right?
Generally, yes.
Okay.
Generally,
Okay.
that's what I said, yes.
And so what the FBI was asked to do in this case then was to find out if there was evidence that would point towards someone planting the evidence against Mr. Avery, as he has said, police officers, right? That was one scenario that you were looking into.
That's correct.
Or whether or not perhaps Mr. Avery was just full of hot air and making this up, right?
No, sir. I wouldn't say that that was the other scenario. The other scenario was whether that blood came from active
All right.
bleeding as opposed to from that tube of EDTA preserved blood.
All right. Don't let me put words in your mouth then, but those were the two scenarios. And as far as you were concerned, you were an objective chemist. You didn't care which way it came down. Is that your testimony?
That's absolutely my testimony.
And that's the position of the FBI, your boss, your organization that you work for. They were taking an objective and independent view in this case and didn't care which way it came down in that analysis. Is that right?
Well, I can't speak for any of my bosses. I'm here testifying for myself. And that is my view of it, yes. I could care less as what the results are, quite frankly.
I'm going to show you what's been marked as Exhibit 479 and see if you can identify that for us, please. I'm going to substitute a copy later, so it's really just the first few pages we're concerned about. The chain of custody isn't at issue here.
Okay. The first few pages are a copy of the internal communication that the FBI uses to essentially write memos between field offices and divisions within the FBI. And this is the specific request that was sent in to me for analysis in this particular case.
Okay. And did you read the sentence on the top of the page, the two that discusses the purpose of this request for your services?
The purpose of this request is to establish the presence of EDTA in the vial of blood, thereby eliminating the allegations that this vial was used to plant evidence.
Okay. Can you show me anywhere in there where that request says our purposes is also to find out if there might be any evidence that there's a corrupt cop in Manitowoc County?
No, I don't see anything of that nature.
Okay.
But I can elaborate if you would like.
So the purpose of the FBI's request of your laboratory to get involved in this case, the state crime, let me step back for a second. The FBI generally is a law enforcement branch for federal crimes, correct?
That's correct.
You don't typically get involved in run-of-the-mill state crimes, do you?
That's incorrect.
Well, unless someone brings you in from the state level for some particular reason, it's not normally the kind of case where you take jurisdiction, is it?
40% of cases that we work in my unit come from state and local investigations. So I would say it's a significant number.
Is homicide of a citizen in the state of Wisconsin a federal crime?
No, sir, it's not.
Okay. Is mutilation of a corpse in the state of Wisconsin a federal crime?
No.
Okay. So the purpose of you getting your federal agency involved in this state crime was to eliminate the allegation that this vial was used to plant evidence. Isn't that true?
No, sir. If I can elaborate, I will be happy to explain.
You can elaborate later, sir. Now, the protocol that you developed for this case, this test, all right, you began to develop around the beginning of February 1st, something like that?
I believe we began the actual method validation at the very end of January, perhaps the very last day of January.
All right, so January 31st, let's say, okay? The protocol was completed on February 14th.
That's correct.
About 2 weeks, right?
Let me correct that. The protocol was issued.
I said completed. I'll get to the differences in a second.
The protocol was completed and issued on February 15th.
Okay, was issued on the 15th, but it was actually completed on the 14th, other than the review process still, right?
Well, it's not technically complete until it passes the review process.
Okay, and this so-called validation studies, or whatever you told us was ongoing, that was done on February 14, right?
Can I refer to my notes?
No. Sure.
I believe the last validation test was performed on February 13th.
Okay, thank you. So February 13. So really 14 days then, if you started on the 31st of January, right?
Yes, 14 days.
Okay, but as you said, it's not complete unless it goes through an approval process, right?
That's correct.
And the approval process, in your instance, I think you said, I'm not sure if you did say actually, but I think you did. Yes, you said you had another scientist look at it.
Which part are you referring to, sir?
Well, between February 13 and 15th, did you have somebody else look at this protocol before it was issued?
Yes, I did.
Who was that?
I had, well, if I can clarify things, I had another scientist review all of the validation
Okay.
data before the protocol was issued.
Who was that?
Madeline Montgomery.
And is Madeline Montgomery in some independent lab?
No, she's within the FBI laboratory chemistry unit.
And she's in the very same chemistry unit as yourself?
Yes, she is.
Okay. Anybody else?
Reviewing the validation data, only the chemist that did the actual work.
And that wouldn't count for your approval purposes. You have to have somebody else take a look at this, right?
No, sir. I mean, the first person that does the work has to, of course, review it and verify all the data is correct. So that's your first level review. Then you follow that up with a second level review by an independent person and who wasn't involved in the study at all. And I always assign that to a supervisory chemist within the unit, someone with more experience, etc.
Okay. Someone in your unit, though, right?
It has to be done in the same unit in which they are qualified to do the work. We couldn't get it to a DNA examiner. They're not a chemist.
Of course. Anybody else look at this validation data besides yourself and Ms. Montgomery and the technician who ran it?
I don't believe so.
Okay. Well, I believe we learned a little bit earlier before the break that the FBI has something called a Forensic Science Research Division, don't they?
Yes, they do. They have a research unit.
And in fact, that's where you said Mr. Miller and Mr. McCord were working. It's called the Forensic Science Research and Training Center, right?
That's correct.
And these people don't work on cases.
No, they don't.
They just do research, right?
They do long-term research primarily.
And that includes developing protocols for new types of tests, right?
Not in recent years, no. Most of these duties fall back on the case working units, as I indicated.
Oh, really? You don't, these are scientists who are doing research, but you don't have them ever look at your new protocols? You let the caseworkers do that?
Yes, I mean, I think in this instance, the people that work under me are more qualified to look at this particular type of an analysis. The research unit these days are heavily focused in dealing with homeland security issues. They would not have the time to review this type of material.
Well, you didn't think you had the time either initially, right?
That's correct, but I could make myself make the time. I can't make them make the time.
Just so we're clear then, you did not have any scientist researcher from the FBI Forensic Science Research and Training Center review your validation data or the protocol that you used in this case before using it in Mr. Avery's case, right?
That's correct.
Okay, this Madeline Montgomery that's in your unit?
Yes, she is.
She's the one you said had independently reviewed the validation data.
Yes.
Does she report to you?
Yes, she does.
do you review her work?
Yes, I do.
Do you decide her raises and promotions?
I do, yes.
Okay. And that's your idea of an independent scientist?
Absolutely. We train our scientists to be unbiased.
Actually, while I'm on that, you talked about how peer review is done for articles that get published in scientific journals, right?
Yes, that's correct.
And that before anything gets put into some sort of publication that has any reputation worthwhile, the editor takes it from the author, the manuscript from the author, and finds some other scientist to review it.
Yes, that's correct. Qualified scientists based on the editor's opinion.
Right. And you say that that's done blindly so that, there's no bias involved by the reviewers, right?
That's exactly right.
And that's important in order to be fair and make sure that you can weed out any kind of bias that one individual may have, either for or against another.
Yes, I believe that's true.
But you didn't have Ms. Montgomery or Mr. or the technician who did this case run through these tests in a blind fashion, did you?
Not blind specifically for the evidence in the case, but we did do some blind testing before we issued the protocol.
And the protocol, just so we're clear, didn't grow out of any kind of ongoing research project that you were doing in your lab, right?
That's correct. It was based on the publication, as I indicated earlier.
No. What I'm saying is it didn't grow out of, it didn't develop because of some ongoing project separate from Mr. Avery's case.
No. The protocol was validated and reviewed and put into use specifically for this case.
And only this case so far, right?
So far, yes.
Okay. And as you say, the data stuff was done on the 13th of February and it was issued on the 15th, right?
Which
The protocol.
data stuff? I'm sorry.
You said that all of the data acquisition, however that was being done by these validation, what you call validation tests, was completed on the 13th, right?
The validation work was completed. The last day of the validation was the 13th of February.
And it was formally issued and adopted by your laboratory on the 15th of February, right?
Yes, it was.
Of this year, 2007.
Yes, that's correct.
Okay. And in order to get to that point where it's actually issued, that constitutes an approval process, right?
Absolutely, it does.
And that approval process by your own protocols with the FBI requires approval by the unit chief, right?
That's correct.
As well as someone else, right?
As well as the unit chief over the quality assurance unit, which is an independent unit that oversees all quality within the laboratory.
Now, in this case, you are the unit chief.
I'm the unit chief of the chemistry unit,
right?
But not the quality assurance unit.
So in the protocol, the chain of how these things are supposed to be approved, by the way, this whole approval process is part of quality assurance, right?
That's exactly right.
And the idea is we want to get some other eyes looking at this to make sure the protocols have been followed and that this is valid science, right?
That's right.
Okay.
And other scientists review the procedures before it's issued.
Right. Now, in your case, though, one of those steps was really sort of skipped because you were involved doing the development of the protocol, right?
No, sir, not at all.
Oh, so you just reviewed yourself?
No.
You graded yourself?
No.
Did you find another unit chief besides the quality assurance person?
No, as I indicated, the review is done by another scientist. And the scientist that did the review for the protocol that went through the stepwise procedure to verify again that everything was written as was required by our quality assurance program, that was the validation study that had been completed by Madeline Montgomery. She did an independent review of this procedure and then, I'm not approving it in the sense of I'm saying it's okay to be used. My approval is simply that all the steps for the quality assurance program within my unit have been met.
So,
That's why
sir,
my signature is on the approval line.
the answer to my question then is yes, you skipped a step in the usual approval process because you were the unit chief who would otherwise have to independently approve a new protocol.
No, you are incorrect. No steps were skipped. This is the same approach we take every protocol that's issued within the FBI laboratory. I have to be the final signature for the approval of any protocol that's issued out of my unit.
All right. And so you graded yourself and gave yourself an A+.
I did not.
Objection, Your Honor, as the form of the question.
Sustained.
As part of the discovery request, attorneys file requests and ask your people such as yourself to produce documents, right?
Yes,
You are familiar with that process?
I am, yes.
You are aware that I asked you through Mr. Gahn to disclose the FBI protocol that was used in 1997 in the O.J. Simpson case, right?
I am aware that you asked for that, yes.
Okay. And yet your lab refused to give that to me. Isn't that right?
The attorney that represents our laboratory did indicate that we were not to turn over any other protocol except the one that was used in this particular case, as her opinion was it was the only one relevant.
In her opinion?
For this report.
So in her opinion, your lab didn't want this jury to see the only other protocol, the only other time you have ever tested for EDTA in a bloodstain in any case in this country.
Objection, Your Honor. That was not his testimony.
Sustained.
Well, you knew if you turned over that protocol to the defense, I would use it to cross-examine you, right?
I don't know that.
Well, wouldn't take much of a guess to figure it out that if I had your prior protocol, I could point out to this jury the differences that you made or lack of differences between that protocol and this one, right?
Objection, Your Honor, as to the relevancy of the O.J. Simpson protocol.
Couldn't be more relevant.
Well, I'm going to sustain the objection, though on that basis, if there was, the witness testified and it wasn't his decision, but the attorney's decision not to turn it over, if there's a request for an order to turn it over, that should be directed to the court, so I don't think this witness is in a position to answer. That's why I'm sustaining the objection.
All right. At any rate, because we don't have in front of us today, I assume you didn't bring it, right? Or did you?
No, I did not.
So you didn't bring it. If I asked the court to order you to turn it over today, you don't have it to do that, do you?
No, I do not.
Okay. So because you don't have it, we don't have anything to compare this protocol to the one you used in the OJ case.
No, you don't.
We talked briefly about blind tests. Let's explain a little bit to the jury. There is a concept or a technique that's used in science it's called blind testing. Are you familiar with that?
Yes, I am.
And the idea behind blind testing is that the examiner or the person who is testing the results or the samples doesn't know what they are or where they came from, right?
Sometimes that's considered blind testing, yes. There are other forms of blind testing.
Okay. And one of the reasons that you do, or that the scientists do blind testing, is to remove the possibility of some sort of bias in the examiner's testing process, right?
Yes, that's exactly right.
And so, for instance, when they're testing or when you are testing drugs, they will sometimes have a placebo with one person and the effective drug with another. And the person who is testing it doesn't know one way or the other.
That's right.
Okay. In this case, maybe in all FBI cases, I don't know, but in this case, the person who did the test didn't do a blind test, did he? Let me be more specific because I can see you're already trying to pick that question apart. In this case, the person who tested the swabs in the blood that and the blood that was submitted to you from the Avery case did not do a blind test, did he?
No, he knew that this was evidence related to a case that we were working.
And he knew more than just that it was evidence. He knew exactly what evidence was which, correct?
Yes, yes, he did. I knew which specimen came from which area.
Okay, and the designations that we saw, some of them up there, Q46, Q48, K3, those designations wasn't some blind code that he didn't know what they meant, right?
No, those were the designations that we gave to those individual items that we would refer to within our report.
And when you say we, let's be very clear to the jury, you're talking about yourself and the technician who did the test.
Well, no, I'm sorry. In this instance, when I say we, I mean the entire FBI laboratory. That's the system that we use. Those numbers, letters, number, designation Q43, for example, it's actually assigned by our evidence control unit. They're the very first ones that receive the evidence and do initial assignment of specimen designations to evidence.
Okay, but well, let's name this mystery person who was doing the testing in your case. It's a guy named Jason Brewer, right?
That's correct.
Capital Brewer.
That's correct.
And he's more than just a technician, would you agree?
Well, I would. He's a PhD. He's recently promoted to be an examiner
Okay.
in this area.
And he's the one who actually did all the tests that you then later reviewed, right?
Well, not exactly. He performed most of the analysis, that part is true, but I was reviewing the data all along, and I was with him a great majority of the time that decisions were being made about the order of things and the amount of sample to use, etc.
But you are a busy man. You are a manager, right?
I am a manager, yes.
You don't have time to sit around in the lab while these machines are clicking and whirring, right?
Well, I did make time for this case. I was in the lab a substantial amount of time, actually.
Okay, but is it fair to say that Mr. Brewer is the guy who really, from one test to the other, did all of the LSMSMS and the extractions and the whole protocol? He was involved in every step of your protocol?
There's multiple answers to your question. Could you break it out?
Yeah, that was a bad question. Is it fair to say that Mr. Brewer is the one who did the actual instrument analysis in this case?
Yes, that is fair to say.
Okay. And Mr. Brewer, you have designations of chemists at sort of the lower level?
That's the equivalent of a technician, essentially.
Okay. And then you get promoted to forensic chemist examiner, right?
That's exactly right.
And that allows you to do other things, including expert witness testimony regarding the results of chemical analysis, right?
That is true, yes.
And you've seen Mr. Brewer's resume, have you not?
Yes, I did. I turned it over to you.
Okay. I'm showing you what's marked now as Exhibit 480. This is Jason Brewer's curriculum vitae, right?
Yes, it is.
And would you agree with me that it says in his curriculum vitae that he is qualified by your laboratory to come to court and explain to juries what it is he does in cases?
No, sir, it does not say that on his curriculum vitae that he's qualified to do so.
Oh?
And he's not qualified to do so.
Doesn't this say under his job description here, interpret data, prepare written reports, and provide expert witness testimony regarding the results of chemical analysis?
That's correct. That's what it says. But he was a chemist and qualified as a chemist as a technician. And then just last September, he was promoted to the level of an examiner, but he's still in a training mode as an examiner. He still works cases as a chemist. Until he's qualified, completes his training, passes all the tests, He is not allowed to testify until that is completed and he's certified. He is not a certified examiner at this time, sir.
Well, he is a forensic chemist examiner.
That's his position, his official position title within the U.S. government.
And so, despite the fact that the curriculum vitae that he has, that you turned over to us, that says that he can do that, it's your testimony today that he is not qualified to come here like you are?
That's correct.
Okay. So that's why we're not hearing from him.
That's correct. I supervise his work, and I'm the one that compiled the results and formed the opinion and issued the report. That's why I'm here today.
All right. You say that Mr. Brewer is still in training for courtroom testimony, right?
No, sir, I didn't say that.
Well, you said he's not qualified to come here and testify to this jury about what he did.
That's what I said, yes.
Okay. What sort of courses or training does he need to do to learn how to tell the truth to a jury?
Objection, Your Honor, as to the form of the question.
Sustained.
Let me just turn for a moment to this particular instrument that you use, LS, MS, MS, all right?
Mr. Putin, just before you get into that
You
new
want to stretch?
topic, let's stand up and stretch.
Okay,
Alright, you may resume.
thank you. Let's talk about this instrument, this LS, MS, MS instrument. It's 3 instruments you said together, right?
Yes, sir, it's the LC-MS-MS.
I'm sorry, I'm not a chemist. I keep botching that designation. I'm sorry. I want to explain, make sure the jury understands, because sometimes lay people like myself are in awe of science and machines, and we sometimes think they do more than they can, okay?
Yes.
So this isn't something that you're just push a few buttons, run a sample through, some lights flash and buzzers go off, and then spits out a result at the end of paper results says, this is EDTA, or this is not EDTA, right?
That's correct.
It's nowhere near that simple, right?
No, it's not that simple.
And in fact, what the whole premise of the machine is that it's supposed to somehow determine the characteristic of an ion and whether or not it's consistent with one chemical or another.
That's not technically correct, no.
All right, a series of ions. Is that the correction you wanted?
It's fragments that are ions.
Okay.
That originate from the chemical itself.
Okay. If you turn to, I've handed you what's been marked as exhibit. I'm sorry. What is the exhibit number?
441.
441. And it's entitled Guidelines for Comparison of Mass Spectra, right?
That's correct.
And this is a document that's issued by your unit, the FBI Laboratory Chemistry Unit, right?
That is correct.
On June 21st of 06 is this one, right?
Yes, it is.
And it's signed by yourself at the end, as well as quality assurance people.
Yes, it's signed by myself and 2 other individuals.
Okay. And if you would turn to page 3, there's a section that has a heading that says Determination of Diagnostic Ions in a Mass Spectrum, okay?
Yes, sir.
Your guidelines state, quote, the definition of what makes any given ion characteristic of a particular chemical structure is somewhat nebulous, and there does not appear to be any universally accepted standard in the field. Correct?
Yes, that's what it says.
Okay. And it says that's why you've got to have good and consistent judgment, and you have to employ judgment, subjective judgment, as an examiner when you look at the results of these tests, right?
It does say you should apply good and consistent judgment. It doesn't say subjective, as you indicated there. Oh, my.
Is there any such thing as objective judgment?
I don't know.
I'll take that as a no.
I don't know.
You're going to fight me on that one too.
No.
Okay. And then on the last page, page 10 of 15, actually, limitation section.
I'm sorry. I don't want to. I want to rethink that answer. I do believe there is such thing as an objective judgment.
All right. Go ahead. Turn to page 10 of 15. You got it.
Yes, sir.
Okay. And this is a heading that's called limitation. And again, these are guidelines on how to interpret the results of these tests, right? That's what this document is.
Under mass
spectra
type test.
Yes.
Yes, this is a narrative talking about the general limitations in evaluating mass spectral data.
And this particular section is headed limitations. It's telling you, hold on, there are some limits to this we've got to consider, right?
That's exactly right.
Okay. And doesn't it say, quote, the mere fact that an unknown mass spectrum matches well to the... Okay. And doesn't it say, quote, the mere fact that an unknown mass spectrum matches well to the spectrum of a known standard will rarely by itself be sufficient grounds to claim the presence of that compound in the question sample, correct?
That's correct.
Doesn't it also say that, quote, similarly, the fact that an unknown mass spectrum fails to match that of a known standard generally will not by itself constitute grounds for concluding that the compound is not present in the question spectrum, correct?
That's correct too.
All right. And so what you have to do with these mass spectrum tests is look at a big picture, consider all the data, as well as what comes out of the machine or instrument, correct?
Yes, you have to look at all the data that's generated and put all the pieces of the puzzle together to reach your conclusion.
All right. Your protocol then that was developed on February or issued on February 15th of 2007 for this case only, it's important that whoever do the test follow the protocol as written, correct?
Yes.
And that you are not supposed to just adjust one procedure differently than what's in the protocol.
You're allowed to do that as long as you document the fact that you did make a deviation to the procedure.
Okay. And when you do that, you are actually, by your lab's protocol, you are supposed to fill out some kind of form saying, I want to deviate from the protocol.
Well, it depends. There's two types of deviations. We have what we're called major deviations, which are quality affecting, meaning by doing this deviation, you potentially are going to affect the results of the test, and you have to get a higher level of approval. It has to go up to the quality assurance unit if you're going to do a major deviation. If you're going to do a minor deviation, on the other hand, it simply just requires a notation in the notes with approval by the examiner and myself, and this case approval by me.
All right. Turn to 434 exhibit, please. Page 3 of 9, number 9, procedure. Got that?
Yes, sir.
Sets forth 5 steps to follow, right?
Yes, sir.
And the last step after you do this filtrate, and I'm not going to bore everybody with the scientific jargon, but is that you're supposed to transfer this solution that you come up with first and inject it into a system that's a negative ion mode, correct?
That's what the procedure says, yes.
And then you follow that up and inject some of the other samples, if there are positive, and into the positive ion mode, correct?
That's correct.
And in this case, Mr. Brewer did the reverse, didn't he?
Yes, he did.
He injected it first into the positive ion mode, right?
Yes, he did.
And then into the negative ion.
Yes, he did, per my instructions.
Okay, your instructions?
Yes.
Okay, so on the very first time you used this protocol, you started changing the procedures around.
No, sir. Consider that a minor deviation. Simply, it's like you put your right shoe on first and your left shoe.
Okay.
It's that simple.
The exhibit in front of you also in paragraph 2, number 2, I should say not paragraph 2, first page.
Paragraph 2, first page.
Not paragraph 2, item number 2, where it says scope.
Yes, sir.
It says that this procedure allows for the screening and confirmation of EDTA in suspected blood stains, right?
That's correct.
The protocol isn't actually validated to quantitate a particular specific level of EDTA, correct?
That's exactly right.
And the difference, just so we're clear, is that protocol is designed to see if there's any level of EDTA that can be detected above your bar, your limit, right?
Yes, that's the part of it, yes.
But the protocol is not designed to allow you to actually fix a number and say, this is 500 micrograms or whatever, right?
It's not validated to provide an accurate number of any measurement we make where we put a number on it.
Okay. Mass spec instruments, though, you can't set up a protocol and they are sometimes used to actually quantitate, right?
Yes, they are.
But you didn't use the instrument in this type of protocol to do that, right?
That's correct. We did not.
And you did not, for instance, when you tested the blood in the blood vial that had Mr. Avery's name on it, you didn't quantitate what level of EDTA was in that tube, right?
It wasn't validated to the quantitative analysis, so we did not
All right.
put a specific value on the amount of EDTA that was present in the tube.
That's fine. That's all I'm asking. You didn't do it, right?
That's right.
And you issued your report, exhibit, what is it, 326? No. Do you have the report up there with you?
Yes, I do.
What is that number?
Exhibit 435.
435. You didn't, as per the protocol, you didn't express any kind of opinion in the report about how much, if any, EDTA was detected in that vial from Mr. Avery's blood, right?
No, I did not.
Okay. And one of the things that was kind of really unique about it, or is unique about this case, is that when you were testing that purple vial, it's 11 years old, right?
Yes, I believe it was.
It was drawn from Mr. Avery's arm in January of 1996 and tested in your lab in February of 2007, correct?
I would have to refer to my notes.
Go ahead.
Yes, that's a correct statement.
Okay. And we talked a little bit, or you talked a little bit about this, I think, with Mr. Gahn, but the whole question of the stability or lack of stability of this chemical EDTA is an issue of research, correct? In the scientific community.
I don't know how much it's researched these days. I think it's very well documented. I don't know how much ongoing research there is on that.
Well, you mentioned that it's a concern that some environmentalists have that this chemical could be building up in our water and our soil, right?
That's correct, yes.
And on the other hand, manufacturers who include this chemical in their products are countering that by saying that this is a biodegradable product and will ultimately be dissolved and not be a problem.
No, sir, I don't believe that's true.
Are the manufacturers telling the environmentalists that you're right, this drug is just going to build up in our soil and water forever?
I don't know that the manufacturers are saying anything to the environmentalists.
You're not aware of any debate, ongoing research in that field?
No, sir, I'm not.
But you did mention that you were aware of some degree of studies about the stability of EDTA, right? I believe you testified to that.
Yes, I'm aware of a number of studies that discuss the stability of EDTA, as well as the chemistry references books that talk about the stability of EDTA.
Okay. Can you cite me to any published study, that's ever studied or evaluated the degradation rate of EDTA in an 11-year-old vial of blood?
No, sir.
Can you cite me to any published study that has ever tried to characterize the degradation rate of EDTA in any blood substance, stains, or liquid?
Yes, sir, I can.
What is that?
The Journal of Analytical Toxicology article that I believe you have. I'm sorry, for clarification. Did you say an 11-year-old blood stain?
Well, at first I said 11-year-old, and you're aware there is no study of blood that old, right?
Yes, sir. I'm aware of that.
You do know, though, let me just step back for a second. You do know that EDTA is biodegradable eventually, correct? Or is that the wrong term?
That's the correct term. The research suggests that it's not very biodegradable.
But the research also suggests that it can be broken down, correct?
Extremely harsh conditions, yes.
Well, wastewater treatment plants have been doing studies where they determined that if you increase the pH in the treatment plant, you can break down EDTA quite readily, right?
Well, the published references say that if you boil EDTA in a highly alkaline solution, which would be high pH, it doesn't break down.
You are not aware of studies that talk about using lime in wastewater treatment to increase the pH so that it breaks down?
Well, the lime may be doing other things other than just dealing with pH. And there are numerous steps that they take to break down the EDTA in water, so it's not just lime.
Okay, but there are steps they take to break it down.
Again, very harsh steps.
In your opinion, you have never done any yourself.
Harsh steps.
Harsh, in your opinion, because you have never actually done any of those studies, right?
Harsh in my review of the literature, as they call them. I'm quoting some of the references. They're referring to things that, as a chemist, I consider to be quite harsh.
Have you ever done any kind of experiment yourself to see if you can actually make EDTA break down into its components?
No, I haven't done any studies.
Okay.
But your question is twofold there. And you said into its components. I'm not aware of the components that EDTA breaks into.
Well, at some point, it can be degraded, whether it's harsh or whatever. That's what I'm talking about.
And then it would just fall apart as a molecule.
Okay, I apologize. I don't know all the terminology, but you get my drift, right? You understand the question.
I do understand the question.
And you haven't performed any experiments to break it down, break the molecules apart.
I have not performed any such experiments.
Okay. You did, however, testify about performing a little study just last week, right?
Correct.
And that study was designed to see whether or not you would still be able to detect EDTA in some blood spot cards that you had on, or that one of your lab units had, right, from a number of years ago, or actually 33 months.
I need you to
All right.
repeat that question, please.
It's a little study that you're talking about in which you tried to see if you could still detect EDTA in some spot cards that were 33 months old, is something you did last week, right?
That's correct. Yes, last week.
And you actually did it on February 28th.
If I can refer to my notes.
Go ahead.
Yes, sir, that's correct. February 28th.
Now, on February 26th, you issued the report in this case, right?
That is correct.
With your opinions, right?
That's correct.
The opinions that you knew you'd have to express in court under oath in front of a jury, right?
Correct, yes.
And so when you issued that report, you had done no study whatsoever of whether or not EDTA would be stable enough to be found in some old blood stains or blood vial, correct?
Yeah, I had not personally done it, but it was in the literature.
And the literature you're referring to is this analytical chemistry thing, right?
No, sir. The Journal of Analytical Toxicology did a stability study on EDTA in all blood stains as well.
2 years old, right?
I believe it was 24 months, yes.
Okay, and you knew in this case you were talking about a blood vial that's 11 years old, 5 times longer, right?
Well, my understanding there, the blood stains were just about 2 years old themselves.
Well, if the vial of blood that came out of Mr. Avery's arm on January of 1996 was used to plant the stains on the RAV4 in 2005, then that blood at the time was already almost 9 years old, correct?
That's correct.
And then since that date, another 16 months or so had elapsed.
Yes, that's correct.
Okay, so you issue your report without doing any study of your own on what the stability might be of EDTA in a blood stain, correct?
That is correct.
And so then 2 days later, was that after Mr. Gahn called you and asked you a question that I had raised that you decided to do this study?
No, I decided to do the study based on the letter you sent requesting materials, discovery materials, and one of the items you requested were any studies that the FBI had done on the stability of old bloodstains.
Okay,
It prompted me to start thinking, is there a way that we could do it?
okay,
And then I went to our DNA unit and asked them if they had any old blood cards with EDTA on it, and they did. So we decided to go ahead and run them to see if it would help for this particular case.
okay. So I'm glad you cleared that up. So then this study that you did on stability was because the defense attorney in the case had pointed out to you that something might be lacking in your ability to express an opinion to the jury about how stable EDTA was or was not. Would that be fair?
No, that wouldn't be fair at all, sir.
Okay. Well, we'll let the jury draw whatever inference they want from that. But I'm showing you now I'm sorry, 444. This is your EDTA stability study, right? It's up on the screen.
Oh, that is the summary of the EDTA stability study. Those are my notes doing a quick review of what we found.
Okay. And these are the other notes attached to this study dated February 28 of 07, correct?
That's correct.
And those are Mr. Brewer's initials again.
Yes, that's Dr. Brewer's initials.
Dr. Brewer, I'm sorry.
Yes.
And other than these handwritten notes and this one paragraph, there's nothing else that tells us about this study that you did, right?
No, that's false.
Did you write up some report?
No, there are pages of data that are related to that study.
Okay. Just graphs and charts and things of that nature, right?
That's correct. That's the actual study. This is the interpretation of the study and the notes as to how the study was put together and how it was actually run.
Okay. So would you submit this to some journal to be published in its form?
That one paragraph, I don't believe it would be accepted for publication, sir.
I thought not. Let me just talk about the timing of this for a second. If you had done this test 2 days after you issued your report because you're worried about my cross-examination of you, and if you had found that these...
Objection, Your Honor, to the form of the question, and that's not what his testimony was.
I haven't finished yet, but I will start rephrasing it. If you had done this study 2 days after issuing your report and you knew you were going to come into court and testify under oath about, and if you had gotten results that would show this EDTA really wasn't as stable as you thought it was, you would have a bit of a problem there, wouldn't you?
Well, we would be refuting all the published scientific data out there that suggested that EDTA is incredibly stable complex. So it would be rather a eureka moment, quite frankly.
And so then there would have been no reason for you to do this study at all, right? If it's that clear in the published literature, there would have been no reason for you to do this study 2 days after you issued your report, would there?
Obviously, we didn't do it as part of the method development, so I do not consider it to be a relevant aspect of putting the method together, doing the analysis in this case, and providing the report to the agency that requested the examinations. But I do believe that it assists in the final interpretation. It does assist in answering a question, your specific question that we had not addressed in my unit. It had been addressed in the publication, as I alluded to earlier. I did think it was a good idea to do, since we have available to us blood stains that were 33 months old. I didn't think, as a scientist, that I could just pass that by and not test them.
Well, I'm very glad to hear that, sir.
I'm sorry?
I'm very glad to hear that. As a scientist, you did not just pass that by. But tell me, page 2, which is the only place that describes the actual method that was used, is this a protocol?
I'm sorry?
Is this a protocol for testing the stability of EDTA in 33-month-old bloodstains?
These are the notes describing the steps that were taken in order to conduct the study, but the protocol that we used in the published protocol, the issued standard operating procedure for the analysis of EDTA in dried blood stains.
So, did you submit a protocol to determine the stability of EDTA long-term over many, many months?
I don't think I understand that question.
You just used the protocol you developed to see if there is EDTA in a particular stain at a given time, right? Correct?
Yes.
Which isn't designed to quantitate how much EDTA, if any, is there.
That's right.
My question is, did you develop a protocol as a scientist that would be accepted for peer review that would be designed to determine the stability of EDTA, as the term you actually used here, to determine EDTA stability?
Yes. I believe that the work that was done here is worthy of publication if we decide to write it up and submit it to a journal.
Okay, but you just used the other protocol that you already developed. You didn't develop a new protocol to study how stable EDTA was. Am I right?
I'm sorry, I'm not completely understanding your question. We use this stepwise procedure, page 2.
Let me just ask, very simple. Did you develop a new protocol? The question probably begs the answer, but you did not develop a new protocol and go through your rigorous review and approval and validation and studies and all of that for the specific question of determining the stability of EDTA, correct?
We did not develop a new protocol to address any potential breakdown of EDTA, but we did determine that we could still find EDTA in a 33-month-old blood stain.
And looking at this result, you tested a total of 10 spot cards, right?
That's correct.
That you got from the DNA unit?
Yes.
You didn't know where they came from, right?
I didn't, no.
Didn't know whether they came out of a purple top tube, a yellow top tube, a red top tube, or a gray top tube, right?
Wrong.
Wrong?
That's an incorrect statement you just made.
Okay. How did you know what kind of tube a little spot on a piece of paper came from?
Because I was informed by the analyst in DNA that these were all EDTA bloodstains.
Okay. So you relied on that, whatever information that was?
Yes.
Okay. And when you tested them, you found that 4 of the 10 spot cards you could not detect the iron complex EDTA, correct?
That's correct. 4 out of 10 is failed.
Okay.
The requirements failed to actually make the call. There was an indication of its presence, though.
But something that's an indication that doesn't reach your threshold, you don't make a call.
That's exactly right, because we work conservatively.
Right. Because something that's just an indication could be an indication of other things, right? That's why you have threshold limits, correct?
Well, as we discussed earlier, we have the guideline for mass spectral comparison, which was Exhibit 441, that defines how we interpret the mass spectral data. And those 4 samples fail the requirements in here to actually make the call.
All right. So 40% of the samples that were only 33 months old had already degraded in the EDTA iron complex.
No, sir, I wouldn't say that at all. We don't know what the original concentration of EDTA was of the iron complex in that spot. Additionally, this was done on spot cards, and we validated our method to be done on cotton-tipped swabs. We did not in this study go see, all the steps we talked about earlier about detection limit. We didn't look at the inferences. We didn't look at matrix suppression. We did not do the carryover will probably be irrelevant here, but we didn't do all of the steps for extracting it from a filter paper, a DNA filter paper, which is probably insignificant, but scientifically, I can't say with absolute certainty that that couldn't have some effects because
Okay.
This material may
Sir,
bind more tightly to the filter paper, the bloodstain may, because that's actually what these are designed for. These are spot cards for blood.
those steps you just mentioned, carryover, matrix suppression, limited detections, that's called validation, right?
That's exactly right.
And what you just told us is that you didn't validate this study to detect EDTA in spot cards, right?
That's exactly right.
Thank you. So this study then wouldn't really tell you how stable or not EDTA might be in a liquid form that's 11 years old, right?
That's correct, yes.
You mentioned that you were testing swabs, or your tests were designed for swabs of cotton, right?
Yes, we did all of our validation on cotton tip
Okay.
swabs because that's what we were told the evidentiary material was going to be in this case.
Okay. And cotton swabs are also absorbent, more absorbent than paper. Would you agree or disagree?
I don't know.
You don't know. You haven't tested it, so you don't have an opinion one way or the other.
I don't have an opinion.
Okay. You do have an opinion, though, that EDTA in a blood stain that is on fabric might be absorbed in different ways so that throughout the stain, the level of EDTA is not homogeneous, correct?
Incorrect.
You disagree with that?
Yes.
Okay. Did you shake up the tube when you got it?
Yes, we did.
Mix it up real well?
Yes.
Have no way of knowing if somebody used that vial to plant, as your little PowerPoint showed, drip, 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 whether or not that person would have shaken up the vial, 11-year-old or 9-year-old vial, before doing that, do you?
Could you repeat that question? Excuse
Oh,
me, I think
God.
that you missed one drip.
You have no way of knowing that if somebody used that vial to plant blood in the Hallbog vehicle, whether that person shook that vial up like a scientist would before doing so, do you?
If that was the scenario, then I wouldn't know if they shook that vial first.
Okay. By the way, you never did any. I think you testified about the swabs when you had the photos up there. You kept referring to them as bloodstains here and there, right? Do you recall that?
Yes, that's what they were reported to us as being.
Okay, reported to you, but you didn't do any kind of presumptive tests on them.
No, sir, I'm not qualified serologist.
So the portion when you, well, not you, but when Mr. Brewer cut the swabs, by the way, were you present when he cut the swabs?
Yes, I was.
Okay. You didn't test to be sure that the section that he was cutting did or did not prove presumptively positive for the presence of human blood, right?
Again, I'm not qualified to do that. It was reported to us that this was blood and that had been confirmed by testing at another laboratory.
Well, it had been confirmed to you that somewhere on this swab, the portion of the swab that was cut off by the prior lab had tested that had blood, right? As far as you know.
Yes, that's I believe that's what I said.
Okay. But the portion that was left on those swabs, you don't know that anybody ever tested to see if there was blood, and if so, how much of the swab that was being cut off contained the blood, right?
That's correct.
Okay. You know that blood and EDTA, that EDTA is a binding. You call it chelating, but the same way. Another way of saying binding, right? Molecules,
Right, it binds. It binds metals, that's correct.
particularly metals, right?
Yes,
And so it may bind with one substrate that a stain is sitting on differently than another substrate that a stain is sitting on, right?
if it's not already bound to another metal, yes.
Okay. And by substrate, I'm talking, it's another way of saying surface, particular surface, right?
That's correct.
You only tested 3 swabs that were reported to have been taken or found in the Teresa Halbach vehicle, right?
That's correct.
Do you know how many other swabs or how many other stains were also found in that vehicle?
No, I don't.
Your opinion that there's no EDTA in the swabs from the Halbach vehicle then is limited to the 3 swabs that were presented to you. Isn't that right?
Could you repeat that?
Fucking hate this
Oh
prick.
my God. Why is he listening? Oh my
You
God.
expressed an opinion a little more broadly than perhaps you intended to, I believe, which was that your opinion was, let me look for my notes, that the stains in the Halbach, blood stains in the Halbach vehicle could not have come from the purple vial that you tested, right?
That's correct.
But you're actually referring only to the 3 stain swabs that you tested, correct?
No, I believe my original testimony is what I meant.
Well, are you telling me right now that even though you never tested 3 other swabs of separate blood stains found elsewhere in the RAV4 vehicle, that you're willing to express an opinion that none of those 3 swabs have EDTA either?
I'm willing to conclude that.
Oh, you are?
Yes, sir. If I can elaborate.
Well, no, let me finish my question. So even though you didn't test those other 3 swabs, you're prepared to state that they could not have come from the purple topped vial that you tested of Mr. Avery's blood.
I believe that to be true within a reasonable degree of scientific certainty, yes.
Okay. I just wanted to know how far you were willing to go. And you also give another interesting opinion where I'm not sure exactly how it came out after I objected and it was rephrased, but that you believe the planting scenario, one of those 2, you only gave 2 scenarios there. One, which is that the blood came from a dripping finger that you so helpfully gave us on the screen, right? That was one scenario.
To represent active bleeding, I wouldn't know if it came from a finger or a toe or an arm.
Oh, really? You just picked a dripping finger out, just out of thin air, right?
That's what happened to be at the Microsoft's website.
Oh,
A finger, right?
and that was one scenario. Another scenario would be that someone was pouring out these little drops from the purple top tube, right?
Sure, yes.
And I think if I understood you, you maybe went even farther and said that because of your test on those 3 stains, there was no way that the blood in the RAV4 could have been planted by anybody. Isn't that what you said?
Yes, that was my opinion. That's correct.
Or did you mean that they couldn't have been planted from that purple top tube only?
Well, if you look at all of that information I was given it to this case, my opinion would be that it couldn't have come from the EDTA tube that we tested for or any other EDTA tube.
Okay, but you're not expressing the opinion that it couldn't have been planted from some other blood source that didn't have EDTA already, are you?
No, sir.
Okay.
I'm not saying that.
Okay. And you never tested any swabs that were reported to you to have been recovered from the garage floor or inside Mr. Avery's trailer, were you?
Would you repeat that?
Mhm. You never tested any swabs that were given to you that were reportedly recovered from the garage floor or trailer of Mr. Avery, did you?
No, I wasn't.
Should we approach the bench for a minute, Your Honor?
Members of the jury, we're going to go a little bit longer than normal to get the witness back to Virginia. I'm told we don't have too much to go, but let's take a quick stretch break and then allow the attorneys to finish. You may continue.
Thank you, Judge. Without getting too bogged down in the procedures that followed and the protocol and all that, if you allow me to oversimplify it, as I understand it, you take these swabs, and by the way, let's just clear one thing up. The photograph showed 2 control swabs for each one of these 3 stains, right?
Yes, that's correct.
You didn't test both control swabs, though, did you?
No, standard practice. We leave half for retesting, so we tested one and left the other for future testing if that was deemed necessary.
Well, aren't those swabs supposed to have been taken from different areas of, like, one side or the other of a particular stain?
It's from the general area, that's correct.
But the theory being that you don't swab the exact same area twice. You use the second swab to swab a different control area somewhere around the stain, right?
That's one way to do it, yes.
All right. You don't know how it was done in this case because you weren't there.
That's correct. I was not there.
Okay. But my point is, you didn't take half of each, clip off half of each swab and do it that way, right?
That's correct. We did not.
You just tested one.
Yes.
Okay. As I understand it, what you do is you clip off the swab. You put it in some sort of a little vial or something. You put a solution in there, and it's actually 200 microliters of something of that nature. Does that sound right?
Well, perhaps you're oversimplifying it.
Well, you put a solution into the dry swab sample, right?
You do, yes.
And you allow it to react for a certain period of time, right?
45 minutes.
And your protocol for this particular test, 45 minutes, correct?
Yes, yes.
And then you centrifuge it.
Yes, we do.
And then what that does is it separates the liquid from the solids that drop to the bottom, right?
The liquid portion goes through the filter and it carries with it EDTA and EDTA iron complex that was dissolved into the solution.
And the solids drop to the bottom.
No, sir.
Well, okay. The liquid is at the top.
No, sir. If you would like, I can simplify this.
Please.
Okay.
Simply.
The swabs are cut and put into what's called a molecular weight cut of filter. And it's filtering device sitting in this filter device. And then we add a solution of the internal standard, which I described earlier as a positive control into each sample. That's 200 microliters, which is, again, that is approximately a 20th of a drop. And that is placed into the...
200 microliters.
I'm sorry, I misspoke. It's not.
Yeah, I thought so.
It's approximately 2 drops. Drop. Thank you. It's approximately 2 drops of liquid that are placed onto that swab. And it's left to sit for 45 minutes to allow for time for all the EDTA or a portion of the EDTA and the iron complex to actually go into the water that was added to it. And then we centrifuge it at a high speed to drive the liquid through the filter device, and the liquid goes to the bottom of the tube and the swab, and all the solids remain on the top in the filter itself. And then we analyze the liquid portion.
Okay, so I misspoke. It's the other way around. The liquid is at the bottom, right?
Yes, sir.
All right. And then goes into, there's approximately 200 microliters of liquid, a little less probably by then, right?
A little less, yes.
Okay. Then it goes into a machine called a sampler, right?
No, not exactly.
Well,
It's transferred onto a small sampling container, a vial, which is a sealed glass vial, and then we manually place it onto an auto sampler.
okay. And then the auto sampler basically sucks out just 5 microliters for the test, right?
For each of the individual tests that we run on this, yes.
Correct. So out of each Q49, Q48, Q47, the micro sampler takes 5 auto sampler takes about 5 microliters, leaving 190 or so left, correct?
Well, probably considerably less than 190, but it leaves some residual liquid behind, yes.
Okay. And then it's that 5 microliters that gets tested in the instrument, correct?
That's right.
But you don't save the remaining liquid to be retested by the defense or another lab or anything of that nature, do you?
No, we don't.
And presumably, if you did, that would be one way of verifying the results that came from the 5 microliters that was tested, correct?
That would be one of many ways it could be
Okay.
reevaluated.
Now, EDTA is found, you mentioned, in many, many products, common household products, right?
Yes.
You mentioned shampoos, detergents, and some automotive cleaning products as well, right?
Yes.
Including Armor All?
No.
Makeup?
Some cosmetics.
Okay. Also used in photography?
In some applications of photography, yes.
Okay. And yet, when you tested the controls in this case, you found no EDTA detectable, correct?
That's exactly right.
And that was in the process whereby you have diluted or allowed the solid to react with the 200 microliters of liquid, correct?
That's correct, yes.
If you had allowed that to evaporate down to a smaller amount, if there was any EDTA in the liquid, it would be more concentrated, correct?
Yes, it would be.
You did not do that in this case on the controls, for instance, to rerun them and see if you would detect EDTA at a lower dilution.
No, I don't believe it was necessary to do.
Okay. And by the way, even with this brand new test that you devised, you can't tell the jury to an absolute scientific certainty if there is such a thing that there's no EDTA in any of those bloodstains. All you can say is that there is none detectable given your limits of detection, correct?
Yeah, yes, they're negative at all our limits of detection, which I
Okay.
feel is more than adequate.
I understand that's your opinion, but the point of it is there might be a lower level of detection which might reveal EDTA. Isn't that right?
Well, you could go lower and start detecting environmental contamination from soil and water, but that, I believe, would just confuse the interpretation on this case.
What that might do is just what happened in the OJ case, which is show the jury that there is EDTA in the bloodstain rather than that there is not, correct?
Again, I didn't do the testing in the OJ case, and I'm not fully aware of all of the final findings in that particular case. It's been, I believe, 12 years actually.
All right.
But it's my recollection, to answer your question, that we did not report that there was a significant amount of EDTA in the blood stain in that case.
I want to show you a photograph that we have looked at earlier. Probably one of these two, but I'll show you Exhibit 473 first. Take a look at these two, okay? Have you had a chance to look at that?
Yes, I had.
And is that the blood vial that looked the way it did? And is that the blood vial that looked the way it looked when you got it?
No, sir.
It's changed? The one you got was changed. How?
Well, I can't even verify that this is the same vial based on this photograph, either of these photographs.
Well, I think, counsel, we have had testimony earlier. For your purposes, you can assume that this is the same vial that ultimately made it to the FBI lab. At least we hope, okay?
I'll agree that the witness can assume that that's what the vial that came from the Manitowoc County Clerk of Court's office and was sent to the FBI for your analysis, Doctor.
Okay.
Yes.
So then my question is, the condition, the way that vial looks to you right now in that picture, is that consistent with the way the vial looked on the day that you saw it?
If I can refer to my notes.
Sure.
Again, I really can't tell fully because I can't see all the markings on the vial to verify that it's marked exactly the same as when we received it. But when we received the vial of blood, it came in a different container, as it was indicated earlier. It was sealed into a shipping container like this, and it has a label on the side, and I don't see it either of these photographs. Additionally, the top was sealed with evidence tape on here. Let me correct that last statement. The vial itself was not sealed with evidence tape. It's this outside container that was.
Okay, let me put this up on the screen for you, for the jury. Is this the same exhibit that you're looking at right now?
I'm not sure your microphone is on, Mr. Buting.
Sorry. Is this the same exhibit that you are looking at right now? Does it look the same?
No, sir. I believe that's a different photograph.
Let me see the photograph, please.
Yes.
All right, let's try this one. Okay, I think counsel have agreed. We have got exhibit 473 up on the screen now. Let me ask you, when you did open the vial or the packaging and found the purple vial of blood that said, or that was reported to you to be Stephen Avery's, did it appear to you that the vial had been clearly opened at some point in time?
Yes, it did.
Okay. And is that in part because around the edge, as I zoomed in on this exhibit of the stopper, there appears to be some red blood that is actually seeped into the stopper itself?
That's exactly right. Yes.
Okay. And that's a clear sign that at some point the top had been opened, right?
Yes, it is.
All right. Your opinion that you expressed today are to a reasonable degree of scientific certainty, right?
Yes.
And just as you would do in any other case where you are expressing an opinion to a jury, correct? As an expert?
Yes, based on the science, yes.
All right. Well, let's talk about another case that you were involved in which a protocol was developed rather hurriedly. Not the OJ one that you were not involved in, but a fellow by the name of Dr. William Cybers. Does that ring a bell?
Yes, it does.
Correct me if I'm wrong, but Dr. Cybers was a medical examiner in the state of Florida whose wife passed away, and 9 years later, he was charged with her murder for poisoning, allegedly poisoning her with a particular sort of muscle paralyzing drug, correct? Is that fair summary?
Yes.
Okay. And so what they did was they dug up poor Mrs. Cybers' body and took samples from the tissue of the embalmed tissue of her remains, correct?
Yes, they did.
And then they went to you to develop a protocol to test for a particular drug called fucking choline. That's SUCC. Maybe you can spell it. SUCCINYLCHOLINE. Is that right? Oh, you
No,
bitch.
that's wrong.
Okay, tell us, how do you spell it?
No, that's the correct spelling.
Oh my God. I can't. Okay, you developed a protocol to develop in an effort to determine whether from a metabolite that could be found in someone's postmortem fluids that one could determine if the parent drug had been administered at some earlier time.
I needed to record that before I
So you developed a protocol in that case. First, let me step back. What you were trying to do, what you were asked to do, was to test these postmortem fluids a subject which, by the way, you continue to testify on now in 2007, right? Or 6?
Again, that's a multi-question question. I can't respond to it.
They train you well on courtroom testimony, don't they?
I'm just answering your
Okay.
questions truthfully, sir.
You were correct. That was a bad question. It's getting late. You still teach at conferences about postmortem fluids, right? The testing of postmortem bodily fluids.
I do. That's part of my job.
Right. And it was back in 1999, I think, right?
Yes, it was.
And you were asked in that case to try and see if you could come up with a test protocol that could determine whether or not Dr. Cybers had poisoned his wife with a particular drug. Is that right?
Not entirely correct, no.
Well, you're going to fight me all the way on this, I can see. You developed a protocol to try and find out whether the prosecution's theory that Dr. Cybers had poisoned his wife was correct or not. Correct?
No, sir. That's never the intent of developing a procedure to determine someone's guilt or innocence. It's to simply analyze for the presence of chemical in evidentiary material. We don't decide the guilt or the innocence.
Well, thank God for that.
Objection, Your Honor.
Sustained.
What you were trying to do was test bodily fluid that had been embalmed 9 years earlier and draw some conclusions about whether or not one could make an assessment of whether this parent drug had been administered to the person before they died. Correct?
If I can correct your question a little bit, move these things along. We tested not postmortem fluids, but we tested postmortem tissues, heart, kidney, lung, fat, muscle, as I recall. We were asked to develop the protocol to determine whether or not a chemical called succinyl-ammonial-choline, SUCCINLMNOP, was present in these tissues because another laboratory had found them, and we were asked to verify whether or not that laboratory had indeed identified this particular chemical.
Okay, and your testing indicated a positive finding for that drug in the victim's kidney, right?
That's correct.
And that particular molecule is a metabolite of the drug called that, correct?
Yes, it is.
And your testimony was employed by the prosecution to obtain a conviction of Dr. Cybers for the murder of his wife by means of the injection of this incredibly hard to pronounce drug, correct?
I did testify for the prosecution in that case. That's correct.
And you rendered opinions to a reasonable degree of scientific certainty, didn't you?
I believe I did. If I rendered an opinion, I would make sure it was within a reasonable degree of scientific certainty.
Just as you are today.
Yes, sir.
To a jury, just as we have here today, correct?
To a jury, yes.
And that jury convicted Mr. Cybers, correct?
Yes, they did.
The conviction, however, was reversed by the Court of Appeals in Florida 4 years later, right?
I don't know when, but I do know that they reversed the decision on appeal.
And only after that, when additional tests were done on other tissues or fluids from other deceased persons, was it determined that the very same metabolite that you found in Mrs. Cybers' body was also in theirs? Isn't that right?
That's correct. I would like to elaborate on it.
You can elaborate in a moment, and I'm sure you will take any opportunity you can. But the point being, your protocol was hurriedly developed for the trial of Mr. Cybers' case, right? Mid-trial, while the trial was going on. Yes or no?
I'm trying to answer, but you're not giving me a chance. Yes, it's developed for the Cybers case. It was a court-ordered test that we were told to do.
And you didn't decline, right? You could have said, no, we don't have enough time to do this.
I couldn't decline in its instance, no.
Well, did you tell the court, hey, I just don't have time to do this properly and scientifically?
No, sir. I was told that the Attorney General of the United States was going to call me and request that we do this exam, so I decided I would do it.
Did you tell the jury that you were under pressure to develop a test protocol that you didn't feel comfortable doing?
No, I never told the jury I was uncomfortable developing the test protocol.
Okay.
But I do believe I informed them that it was done under rather rushed circumstances.
Okay. And you never told them that there was any concerns about the scientific validity of the opinions you were expressing either. Were you correct?
There were no concerns, in my opinion, about the scientific certainty of what we did in that particular case.
Okay.
And I stand by it today.
Okay. Except that years later, when you tested, as you should have all along, other tissues from other bodies, you found the same metabolite.
Well, it's a complex question. I can't just answer yes or no. We did test tissues from other bodies when we worked to develop the method and validate the method before it was used on specimens in the cyber case. We did do that. But what happened was years later, we got a new instrument into our laboratory, and we had additional cases that we were requested to analyze for the same analyte. And when we started to move the method over to the new instrument, which was more sensitive than the old method, we started to find this chemical there at very low levels in bodies that we knew had never been exposed to that particular drug. So that was then reported immediately to the investigators in Florida. We did all of that work ourselves. We reported it to the investigators and informed the court of our findings.
Now, just out of the goodness of your heart, you kept testing these samples. Is that what you're saying? There was no ongoing post-conviction litigation that was involved in this case.
No, sir, not at all. As I testified, we continued to test specimens because we were requested to do this examination on other cases in the future.
Okay. And what happened was this. You expressed an opinion in court to the jury that the presence of the metabolite succinylcholine proved to be a scientific certainty the prior presence of or injection of succinylcholine, correct?
Can I see what you're reading from, please?
I just asked you the question.
I don't recall. I would have to see what you're reading from.
Okay, well, I'll show you this in just a moment. In any event, several years later, the Attorney General or the prosecutor in Florida submitted what's called a notice to the court that is marked in it as Exhibit 439, correct?
I don't know what that form is called. I'm sorry.
Well, have you seen this exhibit before?
First time I saw it was yesterday.
Okay, but you saw it yesterday.
Yes.
Okay, I'm going to read you a sentence, and you tell me if you agree or disagree with it. The purpose of this filing is to notify the court and the defendant that the recent scientific testing conducted by the National Medical Services and the Federal Bureau of Investigations Laboratories has discovered that the findings specifically related to this defendant and the testimony of the experts from each of these laboratories, though I believe to be correct at the time of the testimony, can no longer be relied upon. The findings of the presence of succinylcholine in the specimens tested are believed to be accurate and correct. However, the opinions that the succinylcholine proves to a scientific certainty the prior presence of or ingestion of succinylcholine are not correct. End quote.
I disagree with that statement.
You do? Oh, this is the state of Florida versus William Sybers, correct?
Yes, it is.
Okay. Prosecutor apparently agreed with it, correct?
I think you would have to ask the prosecutor. I don't know.
Okay, well, would you like to see the signature of the state's attorney on this document?
Yes.
Do you see that?
Yes.
Okay. By the way, National Medical Services is the lab that you interned at, correct?
I did a 3-month intern there while I was working on my master's in 1987.
A simple yes or no would have been perfectly fine. And
I
in the
can do
trial
that, sir.
of that case, you and Dr. Kevin Ballard from that lab were both testifying for the prosecution, correct?
Yes, we were both called by the prosecution to testify in this case. That's correct.
Do you know how many years Mr. or Dr. Cybers spent in prison before these tests proved to disprove that original thesis?
I believe he's still in prison, sir.
Well, did you ever go to apologize to Dr. Cybers?
No, sir, I did not.
Did you ever send a letter or apology to the jurors who convicted him for giving them an opinion that was later retracted by the prosecutor himself?
No, my bad, because I believed my original testing was accurate, that the specimens did contain what I said they were in those specimens, which was saxillonomonocholine.
And that your opinion was that the presence of that proved poor Mrs. Cybers had been injected by the parent drug.
And that opinion, of course, was based on the research that was available at the time.
And later research proved your opinion to be wrong. Isn't that right, sir?
Not exactly. Later research with more sensitive instrumentation that was not used in the Cybers case proved that we were able to find traces of this chemical now when we used a more sensitive approach that we actually used in this case.
So later science and instrumentation proved your opinion offered to the jury to a reasonable degree of scientific certainty in that case was wrong, correct?
No, sir. I believe all it did is actually confuse the issue.
Just like you're doing here today in Mr. Avery's case, correct?
I hope I'm not confusing the issue, sir.
Well, I hope so too, but I'm pretty sure you are. Thank you, sir. That's all I have.
Mr. Gahn, any redirect?
Yes, Your Honor, just a little bit. Dr. LEBEAU, will you please explain to the jurors how you became involved in the Cybers case, what transpired, and how it was finally resolved?
Yes, I will. There was an investigation of a medical examiner named William Cybers in the state of Florida. It was a very long, ongoing investigation when there was a great deal of evidence. The investigators felt that there was a great deal of evidence against this forensic pathologist in the death of his wife. And the investigation lasted approximately 10 years. Because he was a medical doctor.
I'm going to object unless this is knowledge that he's acquired on his own from his involvement in the case. It's hearsay and it's irrelevant. It's at least hearsay.
I think the background of this case is already established and the witness should move on to his role in it and what he knows happened afterwards, if we haven't heard it already.
The laboratory in Pennsylvania was involved in this case and they analyzed those specimens from her exhumed body for the presence of every single chemical known to man. And they found the presence of this chemical called saxillonomonocholine. And in that, they concluded that that chemical was metabolite that was from saxillonocholine. And that was very well established in the research that dated back into the 50s. But because they were the only laboratory that did this analysis and because they had some prior evidence rejected by the court on that particular case, the court ordered the prosecution to find another laboratory to verify the findings of the laboratory out of Pennsylvania, and they called upon us to do so. So we quickly developed a method to try to identify the presence of this chemical, saxillonomonocholine, in tissues, which is actually one of the most difficult types of analysis to do. And we did identify the presence of this chemical in some of the same tissues that the laboratory in Pennsylvania found it, but not all of them. And I testified to that in the trial, that we were not able to find it in all those tissues and that our method was not sensitive as the method that was used by the laboratory in Pennsylvania. I did conclude at the trial that the only known source of saxillonomonocholine at the time was the injections of the parent drug, succinylocholine. And I testified to that. We did validate the method before it was put into use. We ran negative tissues from other bodies that we knew had never been exposed to succinylocholine or succinylomonocholine. Then, in the years after the trial and the conviction, we were continuing to get requests from other agencies that were claiming that the same laboratory in Pennsylvania had found the presence of this same chemical in old cases, unclosed cases. And after a while, I started to get concerned because it didn't make sense to me that this very unique drug would be used in so many homicide cases. So we started testing using a new instrument, and we transferred the method over to this new instrument that was much more sensitive than what we had used in the past. And in the validating steps for the transfer, we ran some blank tissues again, as we did before we used in the Cybers case. But this time we started to find small amounts of this chemical, succinylomonocholine. And we, as soon as we finished that and we verified the findings, we consulted heavily with the laboratory in Pennsylvania, and we concluded that this was present in very trace amounts naturally in our bodies, at least in post-mortem specimens. So we were the first ones to identify this. And we reported it immediately, not only to the prosecutor in this case, but prosecutors in other cases. And we also immediately put a letter into the Journal of Analytical Toxicology so that the information would be immediately available to anyone else that may be doing this testing. So my opinion at the time, I feel, was correct. At the time, the only known source for the succinylomonocholine came from the parent drug succinylocholine.
And it was your testing for this chemical later on that you notified the court that the technology that you had in place now was finding it.
That's exactly right.
And can you tell this jury how was the cyber case resolved?
My understanding is...
Objection. The court can take judicial notice of how the matter was ultimately resolved. And unless this witness was involved in the resolution, I don't know how that is relevant.
Well, Your Honor, I will take the exhibit that the defense attorney has been reading from. I would like to get a complete reading of the exhibit.
Is the exhibit available?
Yes, it is.
This is exhibit 439 that you have seen before?
Yes, it is.
And do you know how this case was resolved against Mr. Cybers?
Dr. Cybers pled guilty.
Thank you. That's all I have.
Dr. Cybers pled guilty to time served and was released immediately, wasn't he?
That I don't know, sir.
You haven't researched it? You didn't look that up? Is that what you're saying? Do you know that Dr. Cybers was released from prison in 2003 as a result of entering a plea that was time served after this notice was filed with the court?
I'm going to intercept here and stop with your comment. I think the relevance, whatever happened to him later, is borderline. I believe the testimony that's relevant to this case is already on the record.
All right.
Members of the jury, we're going to excuse you for today. I apologise for running late. Again, I will remind you not to discuss the case with each other or with anyone else, and we'll see you tomorrow morning. You may be seated, counsel. I'm not going to take up any of the outstanding motions at this time, but we probably should deal with Exhibit 466, the PowerPoint presentation of the witness that the defence objected to. Defence objected to the admission.
I object to it because it really draws a conclusion that of a finger dripping blood, when the state is trying to argue that they may have been the source of the blood, is highly prejudicial and apparently without any foundation from this witness, according to his own testimony.
Mr. Gahn.
I think that the doctor testified that his PowerPoint demonstration would be helpful to the jury. And I think he explained that on cross-examination that the only reason he used that was because it was in Microsoft. I really don't think it has any impact.
In the court's mind, the jury has already seen it. He's given a satisfactory explanation. I believe the jury understands it was used for illustrative purposes only, and it's consistent with the opinion that he gave. So I'm going to admit Exhibit 466.
I would also move to admit what are those two? The curriculum vitae number 480 of Mr. Brewer, Dr. Brewer. Oh, and number 479, which is the original intake internal communication document.
Are there any exhibits that you marked that are not requesting to be admitted?
I don't believe so. I think we have introduced everything else.
Any objection from the state to any of the marked exhibits being admitted?
Only to the CV of Dr. Brewer. I don't what the purpose of is. Dr. Brewer did not testify.
He did not testify, but there was testimony. He played a role in the testing of the blood, so I'm going to allow the exhibit as well. Anything else today?
Are 475 through 478 in?
Yes.
They are. Okay.
All right. We'll see you tomorrow morning.
Your Honor, may Dr. LEBEAU go back to Virginia?
Assuming the defense isn't asking him to say.
No, we're not. He is welcome to go back to Quantico.
He is excused.